Yes. Worship, I would like to mention item number 14. 14. Worship, if this matter be listed next week. 14. 40. 40. 40. On the, you are for respondent? Yes, I'm for the respondent. What about petitioner? You have the consent? Mr. Wapam. Anyway, on the prayer of Mr. Younger with learned consent for the respondent, remember? The private respondent. You don't know. You don't know. I'm sorry. Why not? So and so. This matter next week. You are for?
Worship, I'm looking about on behalf of the council for the petitioners.
Mr. So and so, then council for the petitioner. Worship, I have similar query in item number 42 and 47. 42 and 47. Yes, yes. But this London members of the bar, item 33 to 39, no adjournment. 33 to 39, no adjournment.
I beg to mention item number 38.
38, no. 33 to 39, no adjournment. We'll take up today.
The principal council is
No.
disposed.
Enough is enough. 33 to 39. 38, you are mentioning 39. 38. You go through the file. Instead of you assisting me, Discord will assist you.
I do not have the instruction to apply.
We'll see. No adjournment. 33 to 39. No adjournment.
May I please, my lord? Lordship, item number 48.
48.
Yes, on behalf of Miss Mary, Lordship. May be listed after 2 weeks. And similar prayer after item number 53, Lordship.
Angami,
Yes, Lordship.
on behalf of the state respondent. Request for and granted
2 weeks. Lordship.
2 weeks time. Mr. So and so, Long Kumar. Long sir. Long sir. That is concept was the present. 48, 41 and 48.
48 and 53, Lordship.
53. Yes, same order.
Lordship.
You just mentioned the name of the, learned counsel for the petitioner. Huh?
May I please, my lord?
Yes.
Lordship, I'd like to mention hearing item number 56.
Yes.
If this matter can be listed on Tuesday, Lordship.
Well, there are so many matters next week.
Then any other date, your lordship?
This two, what is the matter?
Lordship, here the petitioner is aggrieved by the excess drawal of pay, lordship, recovery of excess drawal of pay from the pension benefits of our late husband, lordship.
Recovery.
Yes, lordship.
Next week, we'll see.
Lordship, there is urgency, lordship.
Recovery.
Yes, lordship.
You have deposited.
No, lordship, after her late husband has been retired since 2018, lordship. However, she's yet to receive the pension benefit and she's having
Which fault? Lordship.
PA to DC, lordship.
Who is in default or which fault this has been, it has to be recovered? Excess drawal.
Lordship.
Next week.
Yes, well, next week, your lordship.
Or today or next week?
Next week, your
Actually,
lordship.
lordship,
No, wait. Recovery has already been made.
no, lordship, yes, to lordship. That is why her pension benefit is yet to be processed, lordship, because of this matter, lordship.
So if it is yet to be recovered, it's okay. Next week, we'll see.
Lordship, specific date may be given, lordship.
Tuesday, somewhere,
Tuesday,
next Tuesday.
Lordship. Much obliged, lordship.
56. Item 56.
Yes, lordship.
Okay.
Lordship, I also beg to mention item 20 to 24, your lordship, on behalf of additional G Insang, your lordship. If these matters can be listed on Monday.
Okay. 20 to 25.
20 to 24, my lord.
Okay. Okay. 20 to 24. List this matter on the prayer of Mr. Anangami. Anangami, London State Council. List this matter on Mondays, 18.
I may also be allowed to make a mention on behalf of additional GMT some item 36, your lordship.
No adjournment. 32 to 39, no adjournment.
Lordship.
You need to get the file and go through it.
Lordship. Lordship, item 43.
Yes.
This is on behalf of additional GMT some, your lordship.
Yes.
2 weeks time.
Okay. Do you have any consent from the, have you taken consent?
Yes, I'm told, your lordship.
So Mr. So present. List this matter after 2 weeks.
Give your
On the
blessing.
prayer of Ayangam, yeah, London State Council.
Please, your lordship. Lordship, I beg to mention item number 18, your lordship, on behalf of the council for the petitioner, Mr. Pipi Boy. Lordship is out of station, your lordship, so I pray that this matter may come up after 2 weeks, your lordship.
On the prayer of Mr. So London Council for the petitioner. Petitioner,
Yes, your lordship.
list this matter after 2 weeks.
Obliged, my lord.
That is a lordship. Lordship, I beg to mention item 25, lordship.
25.
Lordship, the state is
After
yet to
2
time.
3 weeks.
3 weeks, lordship.
Lordship,
3 weeks.
it's last years and they've been saying that no instruction for the past 11
If you
years.
check the list, 2017 matter is also there.
That may be,
And
but
2019, 2020. Anyway,
No,
a counter will be required.
yes, that is it, Lordship.
On the prayer of BG Mobi, London Council for the London State Council, list this matter after 2 weeks. So as to enable him to file the counter affidavit.
Internal 6, 12, 22 may be
Interim
continued.
order update first shall continue.
Obliged.
Lordship, I also beg to mention item 31, lordship, on behalf of my colleague AI in lordship.
Yes,
2 weeks time.
2 weeks time.
Hello.
May I please, your lordship?
Hmm.
Lordship, I beg to mention item number 44 and 45.
Yes,
Lordship, since the council for the appellant is out of station, it is prayed that this matter may be listed after 3 weeks.
Lordship,
any
I thought-
objection,
No,
Mr. So London Council for the petition, appellant. Press for listing the matter after 3 weeks. I may so London press council for the London Council. Appearing for respondent has no objection. List this matter after 3 weeks. 44, 45.
Yes, madam.
May I please, your lordship.
Yes,
Lordship, I beg to mention item number 51, your lordship.
51.
Lordship, I beg that the matter be posted after 2 weeks, your lordship.
Yes. After 2 weeks.
Lordship, much.
Please, your lordship. Lordship, I beg to mention item number 14. We are yet to file affidavit,
What affidavit?
affidavit in opposition. However, due to ill health of the respondent,
You are for?
I'm for respondent number 1 and 2.
Okay, Mr. So-and-so learned consent with appearing for respondent number 2, praised for and granted 3 weeks time to file counter affidavit. Mr. BG Mobi, learned state council present. MS so-and-so for petitioner.
Yes, lordship.
Yes, present.
That's what lordship. But this, your lordship, I beg to mention item number 52.
52,
I believe this matter may be listed after 2 weeks.
2 weeks. So-and-so, so-and-so. 52, huh?
Yes, your lordship. Lordship.
Please, lordship. I beg
Yes.
to mention item number 15, 15.
15.
On behalf of Ms. Lucy, she has some difficulties to this, so lordship.
For
Ms.
peti-
Lucy, no,
petitioner.
petitioner, your lordship.
So-and-so, so-and-so, appearing on
weeks,
behalf of
lordship.
so-and-so, so-and-so. Praised for and granted 4 weeks, 3 weeks,
2 weeks.
2 weeks.
Lordship,
Mr. BJ Mobi, learned state council present.
lordship, I beg to mention item number 46.
Mr.
This matter can come up after 1 week.
After 1 week. BJ Mobi present.
There's an interim, lordship,
Ah,
interim in item 46.
interim order was a recent continue.
Lordship.
Yeah, please, your lordship, I'd like to mention item number 16, 17.
16, 17. Yes,
The matter is in disposed. May the matter be listed after 2 weeks.
on the prayer of, you have put respond petitioner.
Yes,
So-and-so learned council.
On behalf of
List
N.
this
Kumar.
matter after 3 weeks. On behalf of N. Kumar. After 2 weeks.
obliged, obliged.
Yes,
May please, your lordship.
yes.
Lordship, I am here before this lower court for praying for passing of the FIR, lordship,
Okay.
in lieu of the compromise made between the parties
Hmm.
in presence of several witnesses, lordship.
If the, who's got,
The
you
complaining,
are appearing to respond to petition number 2 also.
no, I'm appearing for petition number 1, accused. And
Who is appearing for respond number 2?
Yes.
Petition number 2,
And this-
you are appearing. So, you will impose a cost. Why you have to file an FIR unnecessary?
uh,
Why you have to file an FIR unnecessary? If you have to compromise it,
lordship, the
these are
section-
all abuse of process of the law.
lordship, on the amicable settlement and then on the request of the accused.
No, why?
Lordship,
Why
and
you
then the section itself is also a comparable, lordship,
Huh?
section itself is also a comparable section.
Huh?
Section itself,
Go to, if it is compatible, go to the law court.
lordship,
320. CRPC, section 320. If it is compatible.
lordship, I'm here for questioning of the FIR because
Now, if it is compatible, go to civil court, the law court.
lordship, on the last occasion, the accused has filed this petition, but on the liberty to file afresh,
Hmm.
we have on the observation of this honorable court, we have filed a joint application this at this.
That's why I'm asking, why a different lawyer? You
No,
should have represent the petition number 2 also. How can there be a, I'm not inclined to hear two counsel for a petitioner.
Lordship, see, since the accused and the complaining is a different person, that is.
So if it is compoundable, why 482?
Lordship, my humble submission is that. Lordship,
You go to the law and come back tomorrow. If it is compoundable, so it's not maintainable. Have you approached the law court, trial court?
Lordship, and then the lower court, the learning court said that they don't have a jurisdiction to
Where
quash the FIR.
where it is? Where it is?
Lordship, we have approached the,
No, where it is? Have you annexed that order?
no, Lordship.
Then
That's why, Lordship,
is there any order?
no, Lordship, that's why we are approaching the Supreme Court for quashing the FIR. So my humble submission, Lordship, since.
Sir, we'll listen tomorrow. You come with the law. You read section 320 and 482. And some judgment of the Supreme Court and this court. Come back tomorrow. We'll see tomorrow. All right. Otherwise, I'll dismiss it with reason.
Lordship, my humble submission that since the matter, Lordship, that is my humble submission, because
That you have submission I have heard.
Lordship,
After hearing only, I'm saying, after going through your petition. Come back tomorrow.
Lordship,
I'm giving you a chance. Read the provisions, relevant provisions of the law.
and then Lordship, in this particular case, no charge has been also been filed, Lordship.
Doesn't matter. You have approached this court for quashing of the FIR.
Lordship,
Is not it?
Lordship,
So for quashing of the FIR, charges need to be filed.
no, Lordship.
Then
It's on the,
read the relevant provisions of law, come back tomorrow. I will hear you.
Lordship.
Or should I dismiss?
Lordship. I couldn't mean, Lordship, this is quashing of FIR, so I,
See, if the offense is compoundable, who has to compound?
Lordship, I'm coming here in lieu of the compromise between the parties only, Lordship.
No, before that you have to understand.
Lordship.
Heard Mr. So and so, learned counsel for the petitioner. Also heard Mr. B. Zimobi, learned PP for the state of Nagaland, List this matter tomorrow.
Lordship.
So as to enable the
Lordship, tonight I have some personal difficulty, Lordship, and that's why the matter next come Monday,
Monday.
Lordship.
Is there urgency? Are
Lordship,
the police after you?
Lordship,
Is the police after you?
not at all, Lordship. No. On Monday, Lord. Monday.
So, huh? Call for the case diary. Call for the issue notice, returnable 4 weeks, call for the case diary.
Lordship.
I'm just issuing notice,
Lordship.
but maybe on next day, maybe dismissed. It's not maintainable. Find out the law. What was the last petition? Same.
Similar,
Similar, that. Oh, what is the petition?
WPC number 171 of 2023.
Same order.
It was passed on Monday.
Mr. So and so, Mr. City Jamil and Senior Counsel assisted by,
Aliba Ozakam.
and also had Mr. So and so. And Angami,
Lordship.
Learned Counsel appearing for respondent, all the respondents.
All the respondents.
Learned State Council appearing for all. That same order Monday. Just get that,
WPC number 171 of 2023.
same order. Exact, it's
Not,
perimeter,
yes,
same. A post also same.
force is different.
Yeah, you have to say,
JSCO, Junior Soil Conservation
Ah.
Officer.
that post was? What
That
was the
post was assistant project assistant, sorry.
project assistant? So the post, only post will be different. Same order. What to waste time, no?
So far as argument is concerned, Lordship, virtually the petitioner as well as the respondent number 3,
Sir,
who are the contending parties, have almost completed, but this in the course of hearing,
You have to refresh.
Yeah.
This court has forgotten.
respondent number 5
Yes,
has furnished a chart
yes.
showing some discrepancy about the fund sanctioned by the government of India and the amount received by the respondent number 3.
Your Lordship, sorry for disturbance. Lordship, I have filed my affidavit just this morning only. So it may not be in the report.
No. In fact, after you file the affidavit, they are supposed to reply to it. File a reply.
Yes,
Cannot be one-way traffic. There should be, what is the contents of the affidavit?
As per the direction of the court, I have annexed the SSA scheme
Yes.
along with the chart which is already kept in the report, Lordship.
So what to do?
You can take it in the second half, Lordship.
What about the misappropriation?
Lordship, it's a very short affidavit, Lordship.
So you
The content is very short, only the.
have asserted that there is a misappropriation.
Yes, will say that,
So the petitioner may not have a grievances, will reject the prayer of the petitioner, but will direct the concerned authority to have a cause and inquiry.
Lordship, for that is most welcome. We have no objection. If a proper inquiry is conducted, it appears the Union of India will be held responsible for that. Because
Whoever
yes,
involved
no, that is most
should not be
welcome.
spared.
Most welcome. Because what this chart they have prepared, Lordship, it is on the basis of the statements made in the affidavit of respondent number 3 and the affidavit of respondent number 5. This Honorable Court on 22nd August 2023 has passed a clear order directing the Union of India to file an affidavit enclosing the records, documents. It is very clear, specific mention. Casually, they have filed the affidavit. They are stating that the government of India has released this much of amount. They should have enclosed what is the sanction amount, when it was released, to whom it was released, by whom it was received. All this should be furnished and supported by affidavit records. And Lordship will find in the affidavit the verification part, where they have shown the affidavit.
Call the affidavit.
It is like a situation where a drunken person has fired a shot in the air and there was a big sound. So everybody got alarmed.
But the bullet has to fall somewhere. If you fire on the air, it will not just vanish.
Yes,
That will bullet has to fall somewhere.
yes. And the person who has fired the bullet should be held responsible for that. For
It may unfortunately fall on.
for creating unnecessary hardships to others. All the district administration, all the police, they are all involved in this, in connection with this, for example. And then they are busy. Even otherwise, they have so many works to be done. But just because he has plainly shown.
If you want to reply to, because this court has directed the union to file an affidavit, giving you a copy, so that you may
If
file a
necessary,
response to that.
yes.
If you want to file a response, we'll give it time, including the petitioner.
But before that.
Otherwise, on the basis of the documents and having considered your submissions, this is my tentative view.
Lordship.
Unless, see, that's what,
My lord.
unless there's a finding or conclusion, this amount has been given and it has been misappropriated. Is not it?
That is the,
You may not have any grievances.
No, lordship, if I may, my lord. Now, whether the amount is less or as it is, the exact amount. The
The fact is that the fund provision is there for the part-time instructors, Lordship. And some part of it, even if we have to bifurcate the entire amount, it is not that the part-time instructors fund is not being released. That is not the issue.
No, PAB, what is the PAB?
Yes, Lordship, the project.
Of course, there wasn't an approval by the PAB, but money has to be released and money has to be there. They are saying that it's a disputed, who will find out
And as far as
whether they have misappropriated
my lord,
or not.
And Lordship, one vital aspect.
Suppose if there is a finding, or if the misappropriation
my
is
lord,
established,
my lord,
then you may have a cause of action. I mean, you may have a grievance. But
my lord.
as of now, at this
No.
stage, you may not. But what other aspect is that your appointment is for contract for certain period. You
But-
don't have a indefeasible right to continue. But this court has taken a serious note
No.
about the misappropriation.
Then, if I may, my lord, I have two requests, my lord.
So
Yes,
I'll
Lord.
I'll appreciate your petition
No.
for bringing the notice to this court in such a huge kind of embezzlement or misappropriation matter,
My lord,
that practically you don't have as a PTI, don't have a right to seek for continuation or just because there was a fund.
lordship, my lord is fully aware that usually the CSS employs a co-terminus with the fund. So my lord will kindly appreciate the
No,
response.
it depends. That's why I said,
Yes,
what is the guidelines says? This appointment guidelines.
Worship, appointment, all done by the state.
No. What guideline says? You have annexed the guidelines. Is there any provision regarding the appointment and recruitment?
In the meantime, my lord, presuming that the zoning board is going to give a direction for inquiry, my lord, the petition may not be disposed of. Awaiting the outcome of the inquiry. That way, my lord, the zoning board will have a clear view on whether the petition is
Will dispose it of.
lordship.
So you have received a affidavit filed by the
Yes,
central government.
I have received, so and that I have some summary submission.
And do you want to file an affidavit to that?
That is why whether.
Then
after hearing-
let us take up with next Monday, Tuesday or Monday. Because tomorrow, Lana Senior Council may say that I have not been given a chance.
So Lordship may hear me summarily today, and if necessary, I will file affidavit.
No, let us
Hearing me.
sir, let us not go for piecemeal. If you want to file, we'll give you a date. If you don't want to file, we'll record your submission. That's all.
Because Lordship, in the affidavit, lot of miscalculation has been done. I wanted to point it out that. It's a short affidavit filed by the Union of India.
No,
I would like
that's
to-
why I said, whether you want to file in the form of response, written response, or you just want to make a oral submission. Because things has to be brought on record. If it is small, you just file it by tomorrow. We'll take up it Monday.
I can file it, no problem.
And Yangarvati, you'll have to be, please prepare the matter. You be, whatever you want to say, submit black and white, not just placing the records.
Lordship,
I request you to have a deep preparation on this.
Yes.
Because the implication will be serious.
As far as the figure comparison between the affidavit.
This is my tentative view. Here you again,
Respondent number 3 and 5 are concerned. The figure
you do more,
calculation,
you
Lordship,
do more research on it.
it's actually accurate, Lordship. But since my learned senior colleague for the respondent number 3. is
You are-
not
you are-
accurate, yes, Lordship.
You are happy that he's supporting your case.
Lordship,
So you don't have to do homework. It is he
not necessarily, Lordship, but the respondent number 3 and 5's affidavit in opposition.
Under
I have also a comparative calculation which is correct, but as my learned senior colleague for respondent number 3 says, documentary support that this much has actually been released, that is not in the affidavit filed today.
If it is not
Absolutely.
there, on the basis of that, because there is a clear direction of this court on the last
Yes,
other day. So if he has not filed it, we'll go whatever is on the records. We just cannot allow him to allow the central government to go on like this. So we'll fix it at Monday.
Lordship, let it be on 21st. Monday, some part-hurt matters are there. It is already fixed. And then Tuesday and Wednesday, I'm outstation. So the earliest date will be Thursday, Lordship, 21st.
21st is Thursday.
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 It may not take much time, Lordship.
That day only you have to refresh and it's younger Betty, you have to make a submission. In black and white. Please take some time out of your busy schedule. All right. It may have it depends on your submission, not only submission, depends on your case. Entirely depend on you.
Yes.
And since it is my tentative view, you also have some research.
No, Lordship.
Heard Mr. Justice Secretary Counsel for the petitioner. And also heard
I am for respondent number 3.
Angami Learned State Constable 1, 2, and 4, and City Jamil Learned Senior Counsel assisted by
Aliba was a come.
Ali Bazukam. For respondent number 3 and 5.
3 only.
3.
I'm for respondent 5.
Mr. Younger Bati Learned CGC for respondent 5. This matter was taken up for hearing today. However, since this court on 22/8/2023 has directed the Learned CGC to file an affidavit to bring on record the details of the amount sanctioned and granted to the state government. And also to place the guidelines, public instruction that may have been issued by the central government on the scheme of Samagra Shiksha within 2 days. Today, Mr. Younger Bati, that is CGC, submits that he has filed the affidavit as directed by this court. Only this morning. However, the affidavit filed by the CGC, Learned CGC, is not brought on record. Mr. Citizen Learned Senior Counsel appearing for respondent number 3 submits that he has received a copy of the affidavit for which he may be granted some time to file his response. First of all, in view of the above, list this matter on 21/9/2023
As part-time
as a part heard.
in the admission column.
No, it will be. Now we'll take up. It's in the
Lord.
part first preference will be given to this.
None of us. Bless you, Lord.
I'm repeating you, Mr. Younger Bati, please assist the court. Take out some time. keep aside some your important matters for.
As per the last order, he was supposed to file the affidavit within 2 weeks.
Yeah.
And I should get 1 week.
Yes,
So 2 weeks lapsed on 4th of September. But only today they have filed.
it's okay. Let
So
us,
unnecessarily, the matter has been taken.
anyway, let us not be harsh to each other.
You know, this is not on the radar.
But that day, whatever maybe will not adjourn, we'll finish it off.
Item number 19.
Up to. There you go. 19. What is this, sir? Huh? Why? You are PP? Huh? Angami. Okay. What is the matter?
It's difficult for me to come from Allahabad.
Huh?
I am here from Allahabad. It is difficult for me to adjourn today.
No, he said for a time being. You enjoy Kohima? It's a beautiful place.
Yeah,
Since you are from Allahabad.
nice to be here. But this is third time I am here.
Okay.
I have to.
You come for the fourth time.
It is
Enjoy
beautiful.
the beauty and
It is too beautiful for my client.
of this part of the country.
It is too beautiful for my client.
To taxi.
Yes.
I don't know. What is the offense? Why it should be set aside the request?
Offense is under section 403, 406, 417, 418, 420, 506. The dispute is between two brothers, elder and youngest. They are 4 brothers. And under guidance of eldest brother, youngest brother has started his business at native place, district Balia in Uttar Pradesh.
Yes.
And the allegation labeled by the eldest brother that he has cheated him and not returning
Who is
the.
for respondent number 2?
My lord, I'm appearing for respondent number 2.
Are you ready?
Yes.
You, Libika?
The Lordship, has a seat in another court, so it can continue and like then he can come. Or it can defer for some time.
We'll take after some time, let him come.
Keep it at bottom, Lordship. Keep it at bottom.
Yes, you'll remain on the board. Yes.
This application has been filed for granting of bail of the accused.
Yes, I know.
On the last occasion,
Yes. You make your submission.
Worship, I'm approaching this honorable court on line of breach of article 51, your worship. On the last occasion, the learned PP has raised some objection, your lordship.
You make your submission, we'll dispose of the matter now.
Yes, sir. Worship, this case, there was an argument on 12/6/2022. On 12/6/22, there was an argument between the husband and wife. And during that time, the husband hit the wife with a bamboo pole. And the Newland police station, the OC, made a suo motu FIR against the accused. And he was later on booked under 307, that is attempt to murder.
Yes.
To 326, voluntarily causing grievous hurt by dangerous weapon or means. and 506 punishment for criminal intimidation under the IPC, Your Worship. On 16/8/2022, Your Worship, the IO of the case filed the charge sheet. And thereafter, the applicant has approached this the Sessions Court for granting of bail on two occasions, Your Worship. However, on both the occasions, the bail was rejected, Your Worship, on the ground that tampering of evidence and all those and the nature of the offense, since it's been under attempt to murder, and that's why it was rejected. And so we have approached this honorable court saying that after the charge sheet has been filed, till the time of filing of this petition, the trial has not commenced, and the accused has been under incarceration for more than a year without giving the benefit of a speedy trial. And Your Worship, with regard to tampering of evidence and all those, the father of the applicant here is the father of the alleged accused. He's one of the eyewitnesses of the case. And as such, they are from a very economically background, not well-to-do background, Your Worship, and he's the alleged accused is the sole breadwinner of the family, with who is supporting 4 minor children and aged parents, the applicant also. So we are approaching this court that since there has been a delay in commencing of the trial, so he may be allowed to be granted bail, Your Worship.
Yes,
May I please the Lordship? Lordship may kindly come to the bail petition, page 12, Lordship. Page.
yes,
The applicant, the residential address is as per the election, as per the electoral roll, I-card.
Mangal Day.
It says that Darang, Assam,
Hmm.
Assam.
Hmm.
And whereas if Lordship may kindly come to page 2. Page 2 of the petition. Here, the petitioner Abdul Kalik, residents of Nyohoto village, Goboto district, Newland, Nagaland, Lordship.
Hmm.
So, from the electoral ID, it clearly shows that the petitioner permanent residence is in Assam. So what our apprehension is that if at all the accused is released on bail, Lordship, then accused is likely to be absconded, Lordship, since they don't reside in the state of Nagaland, Lordship. They are just a temporary residents of Nyohoto village, Dimapur, Newland, under Newland district, Lordship. And secondly, Lordship, the nature of the offense committed by the accused is under section, Lordship is well aware that under section 307, 326, and 507, Lordship. And moreover, Lordship, at page 30, the charge sheet has already been filed, and there is a prima facie which has been established, Lordship.
Where?
Page 30, relevant portion, relevant, page 29 is the type copy, Lordship. Relevant portion, 6th paragraph, on 6th paragraph, may I read from the 6th paragraph, Lordship?
Yes.
On the process of investigation, the accused Nurul Muhammad, 31 years, was thoroughly examined, and he stated that he was born and brought up at his native place Here also it's mentioned Madhu.
Page 29.
Page 29. Page 29 is a type copy, Lordship. Page and the last paragraph. The relevant
On the
portion.
process.
Lordship.
Ah.
On the process of investigation, the accused Nurul Mohammed, 31 years, was thoroughly examined and he stated that he was born and brought up at his native place, Madurai. He had 5 sisters and 2 brothers. He was the eldest among the brothers. He was married to Kalima, the victim, 31 in the year 2006, and blessed with 4 children, 2 daughters and 2 sons. In the year 2010, his family shifted to Newland. On 12/6/2022, due to the family problem, an argument arose between his wife Kalima. Out of anger, he hit her with a bamboo pole on the left leg, which was kept for locking the door. In meantime, his father Abdul, the present petitioner, Abdul Khalid, 55 years, came to rescue his daughter. Rescue his daughter-in-law Kalima, was also hit by the same object on the head, and as a result, both of them received grievous injuries due to the impact inflicted by the bamboo pole. Measuring approximate 5-10 feet later, he voluntarily admitted his guilt for committing such illegal act. Next page, Lordship. In the process of investigation, the available witnesses which are well acquainted with the fact of the case was thoroughly examined, and they stated that the accused person was arrested for physically assaulting and attempting to murder 2 persons, namely Kalima, 31, and Abdul Khalid, 55 years. During the course of investigation, the accused so-and-so was forwarded into the Honorable Court for 15 days judicial custody for the interest of investigation. In the process of further investigation,
Whether the family members have been, the statement of family members have been recorded
Lordship, the latest,
other than the victim,
no, Lordship, as far as
the status of the case,
PW2 and 3 has been examined.
who are they?
PW2 and 3.
Are they family members?
No, Lordship. They will be examined only on 26/9/23, Lordship, this month. 26. And moreover, Lordship, from the charge sheet, it has been established beyond reasonable doubt, Lordship.
It's okay.
Lordship,
No, it's okay.
on 2 occasions, Lordship.
Charge sheet has been filed, charges have been framed,
Lordship,
that's why a trial on.
Lordship.
So
And moreover, Lordship, on 2 occasions, they moved the bail before the lower court below.
lower court is
And-
till the family members are,
Lordship,
till the statements of the family members are taken.
Lordship. I will
What is the
call it.
apprehension of the court below?
So in that way of the
How
matter,
many days
Lordship,
will allow with whatever conditions you want will impose,
Lordship,
right?
Lordship.
Mr. Jetkunluk, yes, Lord, learned counsel for the petitioner. And also had Mr. V.G. Momi, learned public prosecutor for the state of Nagaland. By filing this application under section 439 of CRPC, 1972. The applicant press for release of the accused person, namely Sri Nurul Mohammed.
is the applicant is Nurul Mohammed.
No, applicant is not Nurul Mohammed.
Oh, sorry, Your Worship. Yes, the accused.
Accused is
Nurul Mohammed alias Nur Mohammed.
Nurul Mohammed, alias Nur Mohammed, in connection with Newland PS case number 0014 of 2022 under section 307, 326 and 506 of IPC. He was arrested on, when he was arrested?
On 12/6/2022.
2022. since then, 12/6/2022. Next bill, the applicant claims to be the father of the accused is Nurul Muhammad alias Nur Muhammad. Next bill. The brief facts of the case is that on 12/6/2022 at around 22:30 hours, and information was received from the sources that one person within bracket non-local bracket clause had tried to murder his father and his wife with blunt object within bracket bamboo bracket clause pole POLE. On reaching the spot at Nihoto village, the person was identified as Nurul Muhammad. The person was identified as Nurul Muhammad. Listed. As a result of which his father Abdul Khalek and his wife received grievous injuries on the head and leg and hand due to infliction of bamboo pole, and accordingly Nurul Muhammad was apprehended and the victim was rescued. Next page. On the strength of pursuant to such information, an FIR was lodged. An FIR was registered as Newland PS case number 0014 of 2022 under section 307/326/506 of IPC. Mr. The accused first bail order.
First bail order, your 24/3, that is annexure D, your.
Is 31. Next para. The accused approached the learned trial court for release. The accused applied for bail before the learned trial court. The learned trial court by the order dated 24/3/2023 has rejected the bail application on the ground that prima facie that this is a case established against the prima facie case has been established against the accused for causing grievous harm upon the victims with blunt bamboo pole. Thereafter, another subsequent year to the accused has approached the learned trial court for release him on bail. By order 6/6/2023, the learned trial court has rejected the bail application of the accused on the ground that if the accused is to be enlarged on bail, the same may be done only after examination of the family members. Mr. Jet Kundu, learned counsel to the applicant, submits that The accused is languishing in the jail since 12/6/2022.
Yes,
Which is
15 months, about 15 months.
which is about 15 months. The charge sheet has already been filed and the trial has already commenced. The police has filed a charge sheet. The charges have been framed and trial has already been commenced. Therefore, there is no requirement in putting the accused in jail. The petitioner is you are working as
Daily wage.
a daily wage worker, who is the bread earner of the family. Moreover, the bail application has been filed by the father of the accused, who is alleged to be a victim, one of the victims. Therefore, trust for release the accused person on bail. Next paragraph, Mr. V.G. Mohammed, learned public prosecutor, submits that. Says the petitioner is a resident of what? Which place? Permanent resident of
Assam. Page 12.
Wahai. What is this? What is the address?
Mangal Doi. Mangal Doi.
Ah,
Darang Assam. District Darang Assam.
Since the accused is a permanent resident of Mangaldoy in the district of Darang, Assam, if the accused is released on bail, there is a likelihood of absconding, and he may not escape from the trial. Moreover, as per the charge sheet, there is a prima facie case established against the accused, and the charges have been tried. The charges have been framed, and the trial has already been commenced. However, no family members, the evidence of family members have been recorded as on date, which is fixed on
26.
the next date fixed on 26/9/2023 laws for recording of the laws, recording of evidence of the family members. In view of such situation, the accused is not entitled to be released on bail. Next one. CD is there. The LCR.
LCR is there, Lord.
I have considered the submission of the learned council for the petition, the learned council for the parties, and also peruse the copy of the LCR. It is seen that though the trial has commenced, the family members, the evidence of family members have not been recorded as on date, which is fixed for recording the evidence on 26/9/2023. However, in the considered way of this court, the recording of the evidence in the trial stage would not be a bar to release the accused person on bail. The accused has been the accused was arrested on 12/6/2022. And he has been put behind the bar. Since then, he's in the judicial custody for more than 15 months, about 15 months. In such view of the matter, in such situation, in the facts and circumstances, in such facts and circumstances, this court is inclined to grant bail to the accused person. Accordingly, the petitioner, the accused, Mr. Nurul Muhammad is granted the bail bond of rupees.
Your worship,
15,000.
15, okay.
15,000 with surety of life and to the satisfaction of the learned court below, to the satisfaction of the learned CGM.
It's session, district session judge.
To the satisfaction of the learned session judge, Dimapur. On the following conditions. What conditions you want?
Lordship, on the condition that, as and when the accused are called, Lordship, to appear before the court or as and when called for, Lordship.
On the following condition. Number one, the accused shall cooperate with the trial,
Lordship.
and he will appear as and when his appearance is required by the learned trial court. This next one. The accused shall not
Abscond.
abscond, that we cannot say. We'll say he will not meet the family members. Or rather, we'll ask them to meet and reconcile.
They are
accused
not
shall
going
not
to reconcile.
in any manner intimidate with the family members, with his family members.
And Lordship, there is apprehension that the accused might abscond from the station, Lordship, because they reside in Assam, not
The
in.
accused shall not leave the jurisdiction of the learned trial court, learned sessions court, Dimapur, without the written permission of the
Lordship.
learned trial court. Next. That's all.
Lordship.
Anything else?
Lordship. That is.
Bail application disposed.
Lordship.
Much obliged.
Over 19 hours, 27.
Permission come to 26. What is it?
Is Lordship, the petitioner is praying for release of persist vehicle in connection to Timoko East Police.
Lordship, till that Lordship, I haven't received any instruction from the police station, Dimapur, Lordship.
You will be responsible when his car, his or her car become unusable because of this pendency. Will help. Fix the responsibility on the Mr. Jimobi.
Lordship, in that way of the matter,
Next
let
week,
it come
next
next
week.
week, Lordship. I'll make an endeavor,
Mr.
Lordship.
B. Jimobi, London Public Prosecutor, summons that he is yet to receive the case diary.
Lordship.
Case diary. Mr. So-and-so, Learned Counsel for the prisoner present. List this matter next week. So as to enable the learned PP to produce the case diary. You just get the scan copy.
Lordship. I know.
This matter may be taken up after item 19.
Item 19,
Yes.
why?
I think that item 19 was also ready for hearing.
Same thing,
Yes,
same,
yes.
out of same FIR.
No. This is a different FIR.
Ah,
Just giving propriety to item 19.
why?
Well, they were going to take up the matter because the PP was not here. It's the same PP only.
Huh?
Same PP here. Yes,
Ah.
matter also.
Ready?
State
You will take up this.
Okay.
Is it for disposal?
Yes.
Why, court petition?
Three petitions,
Huh?
selling three separate FIRs.
Oh,
Yes. First is
28 to 30,
28 to 30. First is
Yes.
criminal petition 10,
yes,
second is 11, and the third one is 19.
yes.
Yes. These are all, my submission is that these are all connected, but I'll demonstrate that before your lordship.
Different FIRs. Huh?
Different FIRs, but
Ah.
part of the same transaction.
Okay,
Your lordship may have the criminal petition 10.
yes,
The FIR impugned, therein is at page 20. Page 20.
yes.
The basic allegation is that the complainant invested certain amount of money.
Anybody appearing for respondent number 2? Who is it? You are for respondent number 2, okay. Yes,
The allegation in the FIR is that the complainant invested a certain amount of money in a company wherein the petitioner as well as the co-accused, they are directors. The arrangement or the agreement was that after having invested the amount, within 2 years of time, along with interest, the money will be repaid. So the amount here was 14 crore, and within 2 years, then 20 crore was to be returned to the complainant. Having failed to do so, the complainant who filed the instant FIR. The FIR, the basis for the FIR is on the agreement, which is at page 22. Which is at page 22, and the agreement.
is it for quashing the FIR?
Yes, question, Your Lordship.
What is the stage of investigation?
Charge sheet is yet to be filed.
Huh?
Charge sheet is yet to be filed.
Okay,
And this agreement was purportedly executed on 8th March of 2021. By in between, Mr. Pulotosu is the complainant and the company, which is Lake House Private Limited, wherein the two directors, that is, one is Avanish Chandra, he is the petitioner hearing, and the second director is Mr. Varun Kumar Gandhi, he is the co-accused in the FIR. I would allow me to take lordship to the governance in the agreement. Whereas the first party is a businessman by profession. The second party, through its director, Mr. Avanish Chandracha, had approached the first party for one-time investment in real estate scheme. B. The second party approached the first party seeking resources and finance for the investment in real estate property development projects as stated by the second party through its director, Avanish Chandracha. The finances resources were required for the purpose of buying the properties, making it title-free from all encumbrances, making development improvement in the properties by doing civil works and interiors, and thereafter selling them for a considerable profit. The second party assured the first party that it is authorized to deal with and sell the properties the company invested in after making improvements thereon and after clearing all the hurdles, legal and otherwise. Further, the second party has furnished the necessary undertakings
and has furnished the copies of all the necessary documents to substantiate that it has the right and authority to sell the properties in which the first party has invested after making changes, improvements thereon. A total of 10 such properties in Delhi NCR was shown to the first party by Avnish Chandra Jha, director of second party team. The second party promised that even if the project is a failure, the terms of this agreement are strictly binding and second party will be liable as per provision of law and will return the sum assured, that is the principal amount plus guaranteed profits returns to the first party within a stipulated time. E. The second party represented that it needed the resources from the first party, which it did not have, to execute the above mentioned projects, and it represented that in case the resources are provided by the first party, then within a period of 2 years, the aforesaid property will be sold at the premium and the resources borrowed by second party from the first party, along with the guaranteed returns profits, will be shared with the first party within 2 years of the date of this agreement without any further extension or delay. And based on this, the agreement was executed. Now, therefore, in consideration of the promises, mutual covenants, undertakings, representations, and warranties set forth herein and other good and valuable consideration, the receipt and sufficiency of which is hereby acknowledged, the parties covenant and agree as follows. The first clause is the consent clause, and clause 1.1, the execution of this agreement shall mean the acceptance and terms of the conditions as set out in the agreement. If we come to clause 1.2a, mentions the amount, reported amount, rupees so and so, which is paid against receipt issued by the authorized representative of the second party. The authorized representative here, Your Lordship, is the second director, the Varun Kumar Gandhi. The director, Avnish Chandra Jha, has represented that Mr. Varun Kumar is the authorized signatory of the company who will sign on his behalf. And
it says not Varun Kumar, Varun Gandhi.
Varun Kumar Gandhi. Varun Kumar Gandhi. The entire amount has been received by Sri Avnish Chandra Jha of the second party. 1.3. Upon execution of this agreement, it is understood by the parties that the second party will return resources enumerated in paragraph 1.2a, along with guaranteed returns of rupees so and so, only within 2 years of the date of this agreement, without any extension or delay.
You have received the entire amount.
No.
And said so. The entire amount has been received by Avnish Chandra Jha of the second party.
My contention is that this agreement is false, and this has been framed by the co-accused. But I'll demonstrate it, but I'll just take the lordship to the agreement since I'm challenging the FIR here.
In that case, the investigation is required.
No, I'll demonstrate that investigation will not be required. These 3 FIRs are fake, manipulated, and the co-accused has framed the petitioner hearing. Shall not be liable for any loss in business for any reasons whatever at page 2. Page 24 of the petition. Allow me to take a lordship to now clause 2 subclause C. Clause 2.1 subclause C. Here it mentions second party is hereby giving a post-dated check of rupees so and so, dated 31/3/2023, bearing check number 4405 and check number 4414 of rupees so and so, both drawn on Axis Bank Limited Golf Course ROA Gurgaon as an acknowledgement of its accrued debt and liability, and second party trades director Avnish Chandra Jha assures and represents that the check will be honored on its presentation. So in this
agreement is signed by your representative.
Signed by the other director.
Correct. Then why is that before this court?
Because he framed me, and he has been in collusion with police and as well as the representatives of the complainants, which allow me to demonstrate later on, but that's my contention. And in this clause subclause C, the check number will be relevant, and as per the agreement, this agreement was executed on 8th March 2021. So these checks were issued on 8th March 2021. This will also be relevant, which I'll take the lordship later on. And since I'm taking a lordship to this agreement because I have 2 primary contentions insofar as all these 3 petitions are concerned. First is that these FIRs have been filed to harass me, to wreak vengeance upon me. And if that, on the alternative, my alternative submission is that even if your lordship is to come to a conclusion.
No,
that-
before that, you are disowning this agreement?
No, this agreement is fake.
It's a fake.
Yes, this has been.
Have you
set
filed
up
any complaint?
many- Yes, I filed my complaint.
Where
And
it
it's
is?
there in the third petition.
Huh?
It's there in the third petition, I've closed it.
Hmm.
But since these are the facts constituting the FIRs in this petition, I'm just taking a look.
Why so many FIRs? There are different FIRs,
Yes,
3 FIRs.
three FIRs are there. First,
Why? Out of some transaction.
yes,
First by,
to harass me.
no, first by, filed by whom? By same person, respondent number 2.
No, different persons, but these have been set up by the co-accused and the associates. First two FIRs were filed on 1st May this year, 1st May. I filed criminal petition 10 and 11.
We could understand if it's one person, if there are different several persons file FIR against you on the same kind of allegations.
Yes.
Without,
No, my complaint will show that. My complaint has been annexed in the third petition, but the chain of events, I'm trying to show it before this court. And the agreement and this first agreement,
come to FIR,
the FIR,
yes. Read the FIR.
so based on the agreement, this FIR was filed.
All your submissions, I think requires it's a investigation.
No, I would urge your lordship to at least hear me and consider the FIRs in all the three petitions.
Yes.
Once that, after that is clear, the picture will be clear.
No, we'll not just, I'm not interested in the background. We just will have to look
Okay.
into the
The FIR,
contents of
I'll
the
start
FIR.
from the body.
On the face of it, we'll see.
Sir, with due respect, I would like to state few lines for your kind perusal and necessary action, please. I am a businessman by profession, and sometime in the month of March 2021, one Mr. Varun Kumar Gandhi, claiming to be one of the directors of Lake House Private Limited, approached me with business proposal and convinced me to invest in their company, which deals in real estate and property development projects. Mr. Varun Kumar Gandhi, in order to show his credibility, showed me various documents pertaining to his directorship of the said company, and also made a video call to another director, namely Mr. Avnish Chandracha, and together they assured a profit/return on investments in their company. Subsequently, I was deceived to invest. Your lordship may kindly note the word invest, an amount of ₹14 crore in Lake House Private Limited by executing written agreement on 8 March 2021, which was signed by Mr. Varun Kumar Gandhi, claiming to be the authorized signatory of Lake House Private Limited. As per the agreement and instruction from Mr. Varun Kumar Gandhi and Mr. Avnish Chandracha, I handed over the said amount to their authorized person who had come from Bihar and Delhi for collection of money, and the same was acknowledged by Mr. Varun Kumar Gandhi and Mr. Avnish Chandracha. Further, as per the agreement, I was assured an amount of ₹24 in lieu of my investment within 2 years from the date of execution of the agreement. I was also handed over a post-dated check drawn for Lake House Private Limited from Axis Bank Limited, Golf Course Road Branch, Gurgaon, bearing number 44054 ₹14 crore for capital amount, and check bearing number 4414 for ₹6 crore as profit return to be encashed after 2 years. That, however, on presentation of check bearing number 4405 for ₹14 crores, on 26/4/2023, the check was returned due to account block situation. And upon trying to reach out to the directors of the said company for returning my money as per the agreed terms, the concerned company and its authorized agents has failed to repay the agreed amount of investment. The matter as it stands today, Mr. Varun Kumar Gandhi and Mr. Avnish Chandracha are not responding to my phone calls and are deliberately avoiding any communication with me, and their actions clearly constitute and attracts penal offense.
NIA is also there. NIA case is also there.
Yes, but they have not enforced it.
Huh?
They have not filed petitions under the act.
They have filed.
No, they have not. So this is the first FIR. The check, the lordship may. This is the check at page 23. One of the checks. Page 26. This is the post dated check for 31st March 2023, bearing number 4405. So Basically, that is the allegation in this first FIR.
What is this, which signature is this?
Varun Kumar Gandhi,
Not yours.
no. And in the agreement also, it is Varun Kumar Gandhi.
But you are
Yes.
partner in crimes.
At page 25. But it's a company. And I have an argument that no vicarious liability can be attached to the directors. Page 25, the signatory is second party is signature is Varun Kumar Gandhi's. So that's the first, the allegation in the first FIR.
So you
Similar-
disown the agreement as well as the check. You
Yes.
disown the agreement as well as the check.
Well, that's the allegation.
No, you.
No, that's the allegation. I have not committed anything.
No. Are you disowning the agreement?
No, this agreement, my.
According to you, it's a fake agreement.
Yes, it's a
Wait,
fake agreement.
you
Set
are-
up, framed and set up by the co-accused.
You don't know anything.
No.
Do you actually have the company?
Yes, I am one of the directors. I have annexed that. in
And
the-
Varun Kumar is also
He was.
now
he's-
also a signatory.
He's not a director.
That point of time,
Yes,
not now,
Yes.
at the time of during that period,
yes.
when this agreement and all these
When
things
this
were done.
agreement was purportedly.
And the
executed,
check?
Yes, he was a director.
Whatever check,
As far as the check is concerned, I have enclosed that in a third petition, that the bank account of the company was opened on 15 March. The company came into existence on, just for a moment.
company came
Company
into,
came-
came
company was-
into existence.
Yes, incorporated on 3rd March 2021.
Hmm.
The bank account of the company was opened on 15 March 2021.
Hmm.
And as per the agreement in all the three FIRs, they allege that checks were issued on 8 March 2021 and 9 March. That was before even the bank account of the company was opened.
No, this is of 31st March, page 26.
No, in the third petition, I'm sorry,
Huh?
in the third petition. In the third petition,
No, I have the first petition.
yes, so that is why, in the first
So
petition,
you have established a company for this purpose only.
no,
Still your company is still in existence,
yes, it's in existence.
where it is,
It's based in Delhi.
Delhi.
Yes,
Are you sure?
yes.
Still in
Yes, I
existence?
have annexed papers. But it's in a third petition because of the facts and circumstances which were entered me to. So the allegation in the first FIR.
Hmm.
Second, Lordship may have the second petition.
Hmm.
More or less similar.
11.
Yes, second petition. The FIR is at page 15. Page 15. Here, the complainant is different, but the FIR more or less, the content is same.
Amount also
The
same,
amount is different though. Amount here,
11 crores.
11, and the guaranteed return was 15.
15. Let
And
me check here.
here also, two checks were issued, bearing number 4404 and
Same
Same
agreement,
same agreement,
same purpose.
same agreement, same purpose. Post-dated checks were issued on 8/3/2021.
Where it is?
It's in at page 19. At page 19,
This is page 19 in the agreement.
the agreement records that post-dated checks were issued.
So no, you have not annexed that post-dated check amount.
No, the complainant here, he did not annex the check in his complaint. So that was all I could get.
You have
FIR?
established a company to lure these people.
No, it's not. No, that's the second FIR. During the pendency of the first and second FIR, I was taken to police custody as well as judicial custody. When I was in custody, I was approached by specifically Mr. Varun Kumar Gandhi and another person called Danny Singh and an advocate. They visited me while I was in custody and threatened me to do a compromise and to pay certain amount of money, failing which they will file future fake FIRs in other districts of the state as well as in other states of the country. They visited this was quite occasional. And because of this, I was forced to file another petition, which was criminal petition number 15, seeking criminal petition 15, which is not here in the document, but criminal petition 15 was filed praying for three primary prayers: to club the FIRs, the existing first two FIRs. Second was to club any future fake FIRs which may be filed with the first two FIRs. And third was protection while I was in custody. This
So
led to the third.
What about the petition?
Yes, this led to the third criminal petition. This petition was, since the prayer is different, this has not been clubbed with these three petitions.
No, it's still pending.
It's still pending.
Then that
But I-
will be taken first, taken up first.
That may be subject to the outcome of this.
Huh?
That may be subject to the outcome.
No,
of
this should be, this
But
should be
if-
the outcome of that petition.
There, the
You have
prayers
prayed for clubbing the FIRs.
clubbing the existing FIRs,
Ah.
clubbing any future fake FIRs that may be filed against me
Ah.
in other districts,
That
and
would be-
and protection while I'm in custody.
Yes,
And by order,
protection you have got,
yes, these.
you have got the protection.
Yes, this almost.
So this will be outcome of the, once that is decided to clubbing and everything, then only things we will see the contents of the FIRs.
No, my humble comprehension is that if your lordship is pleased to quash the FIRs, then that petition
It will become
will be
infructuous.
become infructuous.
But
If
this
your
code
lordship
is,
not
this code is of the view that once you have that prayer for clubbing and all other matters, so that will be decided first. This matter along with that, we'll first decide that. Let there be a clubbing of the FIR, and they will see after all those FIR.
Or even in that case, no,
In fact, you should withdraw this, get that
I'm saying
matter
that
disposed of,
the FIRs, they have.
and then you come back.
There is no criminal implication if the lordship says. It's firstly,
Now,
at the course of repetition, these have been filed to wreak vengeance upon me, to harass me.
See,
Secondly, excuse me, and
your
it's not
company-
in nature.
your company, the authorized signatory has entered into an agreement, whatever may be. That is done, you have accepted. You may not be a signatory, but you are director.
No, but here the question, my argument is that the question of vicarious liability will come in. The agreement was executed with the company, not me personally. So the director cannot be made vicariously liable for the acts of the company. That is what the complainants have done, and the company is not the party in all the FIRs. That is one link of the argument. But would your lordship be kind enough to have the third petition as well? The third petition is titled criminal petition number 9.
Yes.
Number 19. At page 27 is the order passed by this honorable court in the petition which I've just mentioned, the clubbing petition, page 27. The operative, page 29 operative order. In the meanwhile, considering the allegations made in paragraph number 18 of the petition, as well as considering the submissions made by the learned counsel for the petitioner, the superintendent of sub-jail Dimapur is directed not to allow any visitors to meet the present petitioner while he is in custody without his consent. So this order was passed on 4th August. On the same day, I was produced before the learned CJM Dimapur for further orders.
Is he still in custody?
Yes, on the same day, I was produced before the learned CJM for further orders in connection with the first two FIRs. Apparently, on that day, the IO, the investigation officer of Sovima, which is under Kohima district, another district, he came with an application seeking remand, police remand of me, on the ground that a new FIR has been filed before the Sovima police station, Kohima district. And based on this, I was taken to police remand, and this necessitated me to file the third criminal petition.
It
Now, the
appears,
allegation I have made that the threats have been made to me, bodily injury to be committed on me. They even went to the extent that I would be, they could make fake encounters against me, saying that they have connections with the underground, as well as high bureaucracy. Now, threats was also made to me to settle the disputes amongst them, and force me, and they were forcing me to first, initially it was 25 crore. After I was taken to Sovima police station, they increased that amount to 50 crore.
do you have the
Those-
records?
Yes.
Do you have the records? CD?
Yes, Lordship. Lordship, the petitioner, as far as the cases are concerned, the petitioner is the brain and heart of the whole conspiracy. They are accused number two.
No,
Karim
it's-
Kumar,
it's-
he's just the face.
It appears it's not as simple as the way you presented the
Yes.
matter. There is something more than what.
It may be very well be, but allow me to, at least your lordship may at least be pleased to allow me to complete this. Take your lordship to the records, insofar as the third petition is concerned. Because I have,
See, you know, this, as you know, this washing of the FIR will have to have at the first place, there must be something or there is nothing.
yes, the first,
Then only you can consider.
my
But
respectful,
this court,
my respectful.
prime
submission-
of this, there is something more than what you,
No, the offences indicted against me, the offences, the breach of trust and cheating.
you may be correct technically.
No, not technically. Even on merit, my submission is that,
Legally, there's something more than.
no, it's an investment. It's an investment, not an entrustment. Now, the Honorable Apex Court has clearly distinguished that an investment and entrustment, there's a difference. They have used the word investment. They invested. They carried out their due diligence before.
That's what I'm saying.
executing
Technically, you may be correct. Legally, there's something more than.
the- But then your lordship may be. at least
Anyway,
pleased to allow me.
continue.
In this manner, the third FIR was filed. On,
Third FIR by the
yes,
some other person.
yes, this third petition challenges the third FIR.
That is what I'm saying. Why? You could understand it had it been only one FIR and one agreement.
This has been set up. And it's there.
How do you know?
I've also made a complaint.
Therefore, let the police find out whether this has been set up.
Before
Whether
it comes to a conclusion.
actually, you have done.
Your lordship may at least allow me to make my submissions,
Yes.
because there are certain records which your lordship may. I
Please
believe
go
that
ahead.
This court may at least peruse those records. So
In
here
fact,
again,
in fact, it should not, it doesn't sound nice, but then such type of petitions, such type of litigants should not be encouraged
so,
by hearing you.
no, with all due respect, your lordship, these FIRs are fake. I have been saying that from the first.
So let the police investigate.
Investigation is completed. They have nothing.
Completed.
Now, the other part, allow me to share that before your lordship. The other part is that this, it's also there in my complaint, which has been annexed in this third petition. The other part, these three FIRs, they've been filed in connection with cases pending in Delhi. These are all arising from Delhi cases. Now, the Delhi complainants, they want to seek vengeance on me. They've deputed their associates, their cons, to file these FIRs. And this complaint, these facts or this has been narrated in my complaint, which I've submitted before the DCP DCP. And a detailed complaint has been submitted by me at page 45 in this petition. That will narrate the entire facts, the chain of events which have led to these three FIRs in Nagaland. Lordship, may kindly have that.
Yes.
There is this FIR, this complaint, which is
Yes.
although yet to be registered.
Third FIR, I mean,
This is
third petition,
yes, in the third petition, this is my complaint.
where it is
Page 45,
45.
page 45.
This was after or before?
After, while I was in police custody at Kohima police station, I was compelled to,
Counter blast,
not counter, but I was compelled to for fear of my life.
counter blast.
Not counter. I would not say it's a counter plus.
Okay,
File dated 17 August 2023. It's a detailed FIR. Lordship may indulge me and allow me to read this FIR. Sir, I, Sri Avanish Chandraja, son of Devendra Kumar, so, presently under police custody in connection with Kohima PS case number 16/23 under section 4(9).
just before that,
Yes,
and here you, this FIR is, where is the FIR? In this
the FIR is
particular
at page 30, page 30.
30,
Yes.
this is of 4/8,
1st August.
4/8, yours is 17,
Yes,
okay.
so
You pursued a complaint and you make your statement before the police, all this not before this court.
As far as I'm concerned, I'm not interested in pursuing the investigation. As far as this complaint is concerned, I'm interested in pursuing, but as far as the other FIRs are concerned, my.
Mr. Erano,
Yes.
I don't want to make your day unfavorable.
Understand that, I appreciate that, but then
I'm
if your lordship is not agreeable, then
Are you for disposal?
can I be frank enough to ask for your lordship's indulgence and allow me to try this before another court then?
Huh?
Allow me to try this before another court,
No, that I'll not, that I'll not.
that your lordship may at least.
I
allow me
may
to
give
take-
you some time, but not that I'll not.
Then your lordship may allow me to take.
See, only quashing of the FI, you also were aware of it. You'll have to read the FI only, or the press of it, nothing else, nothing more than that.
I understand that. So the third petition then. This is the.
Well, read, I've allowed you to read the FIR. Why you should go for this counter blast? I mean, the complaint,
Because
this
it's
has been
true.
filed as a counter blast.
As far as the.
I'll
As
consider
far as
it
the
a counter
petition is
blast.
concerned, it's true. That's my part of the story.
So these are the things which requires the investigation by the police.
It may be.
Just say it cannot be just allowed to trespass. Litigants should not be encouraged.
Then allow me to.
Sir, I understand your predicament.
Then there's a document at page
I had,
42.
this court has also had the experience of some. We are duty
I
bound
appreciate that.
as a lawyer. But at the same time, I believe that we do have a duty towards public also at large.
Then would your lordship kindly have this page?
I'm not saying that, I'm not finding that guilt or not guilt. But
No, I'm not concerned.
so
with
far as today, where the proceedings for quashing of the FIR. Normally, this court, you might have seen it.
that. Then would your lordship be kind enough to have page 42 of the third petition? Page 42. This was the, this is the bank account statement of the company.
Yes.
Here it will show that account open date is 15 March 2021. On the right hand side, account open date,
Yes.
EC open date shows 15 March 2021. In the agreement, purportedly, the checks were issued even before the account was opened. Checks were issued on 8 March 2021 and 9 March 2021. Your lordship may kindly consider the possibility of such checks being issued before even the account of the company was opened. And this is one of the grounds why I'm saying that these FIRs are fake and set up by the co-accused in connivance with those complainants in Delhi. The Delhi case is separate, that may go on, but this has been set up.
That's why I wonder why your authorized signatory. You are saying that your member of the company or the board of directors, your colleague has, in connivance with the informant, set up the FIR. That is your submission.
Yes, one of this.
This is something. What about the co-accused?
Co-accused, he's out on bail, roaming free. And in the third complaint, in the third FIR, lordship will see that no allegation has been made.
Have you tried to find out whether this company is still in existence? What's the, I mean, the real status of the company? Is there any status with regard to the
For that,
company?
lordship, they have page 39. of the-
Just wait. I'll hear you, don't worry. Is there anything on records? What about the company?
Yes,
Company is still in existence, is it?
yes. And the petition, in one of the cases, the this clerk mentioned that he's not even cooperating with the investigation agency, lordship.
You know, we'll come, I'll hear you. I'm just wanting to know something. I'll hear you.
So, and next, the one document, page 39, incorporation of the company. The company was incorporated on 3rd March.
39.
Yes. So here, page 39.
Yes.
At the bottom, date of, sorry, in the middle part, date of incorporation is 3rd March 2021.
Yes.
And at the bottom, the present directors are, the names are written, One is the first one is the petitioner.
Hmm.
Second one is the new one. After the co-accused was removed in,
Yes.
the date is also written, second July,
Hmm.
2021.
Hmm.
So he assumed directorship from this date.
Hmm.
As for your lordship's satisfaction, only I have annexed this
Yes.
document. And my complaint is at page 45.
You want to read it?
Yes,
Just tell us. What do you want to say here? You might have narrated what you have submitted here.
more or less,
Ah.
in connection with Delhi case. how
So you just,
fires and
you
fire-
just point out,
Yes, and how in the first instance,
which you have not covered, you just point out.
yes, more or less the same. My submissions have been covered, and this detailed complaint was made.
Hmm.
In the first instance, they demanded 25 crore. After that, I was taken to Saginaw police station. They came even with one the Denny person was holding a gun. He demanded 50 crore, feeling even compelling me to withdraw these petitions as well. And these facts have been narrated in this complaint. As far as today is concerned, I have no knowledge as to whether the complaint has been registered or not.
Have you stated in your affidavit, in your
Yes.
petition,
Yes.
which paragraph?
There will be a paragraph. Starting from 12 at page 13 of the petition. Paragraph 12.
Akito, there is a oral and submission by some members of some learned lawyers that learned lawyers are involved in such activities in the Dimapur. In the open, this court has noticed some lawyers have, learned lawyers have mentioned that orally. In one case, though, I have directed the lawyer to file whatever she or he made a submission, oral submission. I've directed them to file an affidavit. This is the same thing here. Lawyers are involved. It's not duty, as I pointed out. It's not, lawyer's duty is not only, we'll have to read, by
Yes,
the
of course.
Advocates Act
Yes, of course.
and the Bar Council of India rules. It is,
Lordship, matters like this have not been brought to the attention of the bar as yet.
yes.
So if any such documents are filed.
This is one of the, it says, seeing and the same advocate. And one matter to its pending, I've directed him to file a affidavit. I directed the lawyer who had made that submission.
Very well, my lord.
This is something bar needs to, not the judiciary, bar needs to have.
If copies can be furnished to
Yes.
us, Your Lordship, we'll do the needful.
Because it should not be encouraged.
It was only
It
instructed-
amounts to, it's not amounts, it's clearly interference of administration of
Yes, true,
justice.
Your Lords. But if I may, it was on the instruction of the
Yes.
client not to.
Especially
not to mention it.
Dimapur,
Yes, ma'am.
these things are happening, they have submitted. The lawyers involved, they go to the parties. And the part of the threat and all those things. This is something,
Yes, ma'am. If these allegations are on record, Your Lordship, yes, if copies can be furnished to us, we'll do the needful.
that matter, they will be filing, the
Very well.
moment it is there, I'll direct them to.
Very well.
Furnish a copy to the member,
Very well.
bar association. We should take, maybe, that's why I said, if it is young lawyer, we may understand and we'll take them, we'll have some counseling to them and we'll have a, workshop and kind of seminar thing we'll have to do. But if it is senior lawyer, should not be spared.
Yes.
This is very, very unfortunate. These things we need. This is bar, Dimapur bar or Dimapur and it's a
Dimapur Bar
one of the, I mean,
Biggest
biggest bar,
biggest bar.
British bar,
Yes. The biggest bar.
the biggest bar. So this is something we should not, I mean, in any course, it should not be allowed to go on. You take
Yes, ma'am.
notice of it
Yes,
and can you talk to the members of the bar?
We'll do that.
This court is not against, but this court is the administration of justice. It's not only by the court. Includes
Lawyers
the
too.
members of the bar. I mean, the lawyers.
I'll do that. I'm obliged for that.
Yes.
So the statements from paragraph 12 to 12.4.
You are also in Dimapur.
No, I'm based here.
You are based here. Can you share a copy to him?
Of
For the
course,
interest of the
course.
bar.
Yes. I'll do that.
It's a clear statement.
Yes.
Same advocate and all those threat, give a threat and all.
Very well, madam.
Why I'm compelled, constrained to point it out because this is the second time I have come across. As I said, other one to this is pending, they'll be filing it, we'll share it. I'll ask the registry to furnish the copy.
Very well, madam. In this case, to your lordship, if a copy is going to be made over to me, can a record of that be made in the?
So that you being a senior, member of the bar, you share it, unofficially.
All right.
Yes,
So in a manner, I've submitted.
who is Danny? Who is Danny Singh?
I don't know, he has been visiting the petitioner. And I may also point out that
Why you are same advocate? First where you have referred?
it's the same person, but
No, where you have referred first, same, you said same advocate?
same advocate.
You must have mentioned it
Yes.
somewhere in some other paragraph. Have you named the name
No,
of the advocates?
I have not named. Your lordship may have page
Just find out that
page 5.
page 5.
Page 5. Paragraph 4.6,
4.3.
4.6. Therein, I've made the statement that he was also, those visitors, they accompanied, the advocate also accompanied those associates of the complainants. And an advocate. On the instructions of the client, I've not mentioned the name of the advocate.
A lawyer should not visit the police station unless you are required under the law.
True.
Just because client wants you to visit. Should not.
May I also take the lordship to one paragraph of my complaint.
Yes,
At page 48.
it's 48.
Page 48. This is continuation of my complaint. It's a detailed complaint, but I just want to point out one paragraph. The third paragraph, page 48.
Yes.
Third paragraph, it is categorically stated. It is categorically stated that even while I am in police custody at Kohima, Gaurav Gandhi, Daini and his friends with gun, along with a lawyer, regularly came to meet me against my will and have physically and mentally harassed me. On 9/8/23, Daini has come with his gun and demanded ₹50 crore bracket extortion and threatened me with dire consequences if I fail to make the payment. I was also physically abused by him. He also contacted one person through his phone from police station, and I was made to talk with that person who introduced himself as Special Commissioner of Police, Crime Branch, Delhi. He told me that after clearing of all litigations in Delhi High Court and Supreme Court, the FIRs has still been filed in his direction in Delhi Crime Branch and in Nagaland, and that I could not do anything. He also threatened me that in the same way, we will register FIRs in Nagaland, in other Northeast states, in Haryana and Punjab, Shimla in future, and will register several charges against me and will let me be in custody for years in the event I fail to pay them rupees 50 crore. Then again on 13th.
Is there any case in Delhi in
Yes, there are two at
Delhi High Court?
at the moment, no, before the district courts.
District Court?
Yes, two cases.
What about Supreme Court?
Supreme Court, as far as my knowledge is concerned, at the moment, no.
No cases in
No
Delhi High
cases.
Court and Supreme
Like Delhi
Court?
High Court pending. Relating to property disputes.
Huh?
Property disputes cases pending before the Delhi High Court.
With whom? Barun? With Barun?
No, with the complainant in Delhi FIR, with one of the complainants.
Who
It's
is
a
the
property-
complainant there? Against you?
Yes,
Against you?
between us.
Who is that complainant?
His name is Anil Nanda.
Oh, he's not connected. Different property disputes
Property dispute.
between
Yes,
Anil Nanda and you.
Anil Nanda. After the Delhi High Court's order was passed, he filed the FIRs. And one or two orders I've enclosed in the first criminal petition. That part you also may have in the first, at page 45, in the first paragraph, I have the complaint in the complaint. Page 45. After the bolded section, it is most respectfully and earnestly submitted that I was arrested in connection with a fabricated complaint case made against me by one person, Prasad Nanda, and the complainant, along with other high-ranking police officers, politicians, career persons, succeeded to get the case registered against me with a FIR number 295/22, registered at the Crime Branch, Delhi, which is presently pending before the Honorable Court at Second District Court. That thereafter, another false and concocted complaint was made against me by Rajneesh Anda, and they were able to get the complaint registered using the same tactic with a FIR number 97/23 at Crime Branch Push, Bihar, Delhi, which is presently pending before the Patiala District Court.
That is the problem, sir. You are not,
That I have
you
acknowledged.
appears to be not so that
There may be, but
clean which you are trying to project.
it may be, but this matter concerns Delhi. As
No
far as the
matter,
Nagaland
no
cases are concerned, it has been acknowledged
No
in his complaint that the agreements are false. And the lordship may also consider that the bank account of the company was opened on 15 March
If
2020.
it is purely a civil dispute,
They can settle it. They have not even filed the 140 petition under negotiable instrument, 141, sorry. They have not even filed any civil suit to reclaim the money, and the money is not small. Allegedly, if they had given such amount of money, it's not small. Nobody would be filing criminal complaint except to harass me and to force me to make these negotiations with their demanding. They have not filed any civil suit as of date. If at all, they have invested, reportedly invested with the company. And the manner in which the agreement has also been drafted for such an amount, lordship may not be relevant, but the agreement, the manner in which the agreement has been drafted for such amount, it's not practical. So to sum up, another point I would like to emphasize again at the course of the petition is that the bank account of the company was opened on 15 March 2021. The agreements, all the three agreements, they allege that checks were issued on 8 March 2021 and 9 March 2021 before the bank account of the company was.
that is 31st March, one is 31st March in item 1.
That's supposed data check for 31st March 2023.
Okay.
So when the bank account was not even opened on 15/3,
Before
can they
the
issue checks?
company was established.
after company was incorporated on 3rd March,
Ah,
bank account of the company was opened on 15 March.
ah.
In between, when the bank account of the company was not even opened, how can checks be issued on 8 March 2021 and 9 March 2021, as acknowledged in the agreement, as drafted in the agreement? And the other point is that just to show ulterior motive and the manner in which the FIR has been filed. I've taken a ground at page 17 of the instant petition. That,
17.
yes, page 17, ground D. Here, I'll just read it out. Further, the vexatious nature of the instant FIR, including the entire purported transactions from the first FIR to the present FIR, is also seen from the fact that the purported post-dated check issued to respondent number 2 hearing with the agreement dated 9/3/2021 bears the check number 4413. Whereas one of the post-dated checks for 31st March 2023 issued to the complainant therein in GR 302 corresponding with first FIR with FIR number 29/23, which is the first FIR in criminal petition number 10 is numbered as 4414. And when the said agreement was executed on 8/3/2021. Concurrently, one of the checks issued to the complainant in GR 396 of 23 corresponding with FIR number 20 of 2023 Newland Police Station is numbered as 4412 when the agreement was executed on 8/3/2021. Therefore, the question of issuing checks bearing 4412 and 4414 on 8/3/2021 and thereafter issuing check bearing number 4413 on the next day, that is 9/8/2021, exposes the frivolous nature of the FIRs impugned. In view thereof, it is submitted that in the backdrop of the bank account of the company being opened only on 15/3/2021, the entire transaction which took place in all the 3 FIRs is nothing but a sham aimed at only harassing and wreaking vengeance on the petitioner. In this regard, my humble submission is that anybody issuing checks, the checks are numbered serially. Now, first check was issued 4412. Second check was issued 4414 in the first 2 FIRs. But in this instant FIR, 4413 was issued again.
That's exactly precisely I've said the reason that it needs an investigation. And you may be technically correct, but legally, I don't find, this court doesn't find anything to quash the FIR
Very good.
at this stage.
May I at least not be allowed to place my submissions for my own benefit?
So many judgment. Let's see the latest one. 2022.
The latest one.
Hmm.
The relevant is our paragraph 25 and 26.
Huh?
Paragraph 25 and 26.
Which one?
Like A.
Like A.
Yes. The first one.
Paragraph 20, 21, 22.
25.
Okay.
25 merely highlights the Bhajan Lal's case, and I'm relying on clause 1, 3, 5, and 7. And I'm submitting that my case is covered by clauses 1, 3, 5, and 7. May I read it?
Yes.
And where the allegations made in the first information report or the complaint, even if they are taken at their face value and accepted in their entirety, do not prima facie constitute any offense and make out the case against the accused. 3. Where the uncontroverted allegations made in the FIR or complaint and the evidence collected in support of the same do not disclose the commission of any offense and make out the case against the accused. 5. Where the allegations made in the FIR or complaint are so absurd and inherently improbable on the basis of which no prudent person can ever reach a just conclusion that there is sufficient ground for proceeding against the accused. Where a criminal proceeding is where a criminal proceeding is manifestly attended with mala fide and or where the proceeding is maliciously instituted with ulterior motive for wreaking vengeance on the accused and with a view to spite him due to private and personal grudge. And paragraph 26. May I be allowed to read?
Was the question of mala fide or was the question of vengeance or personal grudge? How do we establish?
One is the check at the account opening. One is the account opening. It was opened on 15/3. Checks could not have been issued prior thereto.
Therefore, this is mala fide.
Yes.
Huh?
Yes, one of the grounds which I'm taking is that And secondly, the manner in which the checks, the number of the checks were serially issued to those complainants. Not in sequence.
But sir,
And thirdly,
this court fails to understand such an act, and because of that, it is a malafide.
and amongst others, the entire facts and circumstances would simply point towards that the FIRs have been instituted maliciously to harass me because of the Delhi cases. And this has been sufficiently.
Delhi cases is something different. That is by some other person. Same person.
Meaning to say?
In Delhi cases in Delhi
Yes, in the
is
complaint.
by one which Nanda,
Yes,
not by this present informant.
no. The complainants are different, no doubt.
Yes.
But in his complaint, he has taken the stand that this has been set up by Anil Prasad Nanda and the other complainant.
How you connect these people and Mr. Nanda?
That I
According to you, they are ganged up for, they have the kind of this caucus kind of things.
yes,
Are they gang?
I don't think such statements have been made.
That's what I'm saying. How you connect this Nanda and this present informant?
From in his complaint, the Lordship may kindly have it. It's a detailed one, but I have omitted to read certain paragraphs of the complaint. It's there in the complaint.
No, you said, you have read it out, first page, you said Delhi cases with all these politicians and all that, but you are not able to connect this informant. The informant, the present complaint or informant.
For that, I have nothing to add.
Then how you
But
connect
it
this?
is the apprehension.
We are
of the
not
complaint-
concerned about Delhi cases.
It is the apprehension of the complainant of the petitioner herein that they have been set up. And he has information to that effect, which cannot be brought before this on the court. He has information, but with that as made this, my submission is that it is only based on these facts and circumstances that the instant FIRs have been registered against him.
Why you have filed this, the complaint before the deputy commissioner? Is it deputy
It's-
commissioner
this-
or deputy
Yes.
commissioner of police? Okay.
And
Okay.
I have also, since my complaint was not registered,
Why don't you approach the concerned magistrate?
I have approached the GP. After that, if no action is taken, I intend to approach the magistrate.
Magistrate.
Yes,
You approach. If that is the case.
yes, that's different though, as far as this case is concerned.
No, once we interfere,
Still, this.
suppose if your is allowed, everything goes.
No, if he intends.
If it is not allowed, if it is dismissed, it will heavy on you.
That is up to the client. If
Huh?
he wants to pursue his complaint, he's at liberty to pursue.
No, today you are for a client, I'm not,
Yes,
I'm not,
of course, I understand that.
as Mr. Iralo,
Even if he intends,
As
even if whichever way
as a
this,
spokesperson of
I understand,
your client only.
whichever way the petitions may go. If if the petitioner wants to pursue his complaint, that he is at liberty to pursue his complaint. For that, he has submitted his complaint before the DGP at the
Okay.
moment.
Next.
Next is paragraph 26. The Honorable Supreme Court has been pleased to expound the jurisprudence on section 482 further. And here at paragraph 26. At this stage, we would like to observe something important. Whenever an accused comes before the court invoking either the inherent powers under section 482 of the Code of Criminal Procedure or extraordinary jurisdiction under 226 of the Constitution to get the FIR or the criminal proceedings quashed, essentially on the ground that such proceedings are manifestly frivolous or vexatious or instituted with the ulterior motive for wreaking vengeance. Then in such circumstances, the court owes a duty to look into the FIR with care and a little more close. We say so because once the complainant decides to proceed against the accused with an ulterior motive for wreaking personal vengeance, etc., then he would ensure that the FIR complaint is very well drafted with all the necessary pleadings. The complainant would ensure that the averments made in the FIR complaint are such that they disclose the necessary ingredients to constitute the alleged offense. Therefore, it will not be just enough for the court to look into the averments made in the FIR complaint alone for the purpose of ascertaining whether the necessary ingredients to constitute the alleged offense are disclosed or not. In frivolous or vexatious proceedings, the court owes a duty to look into many other attending circumstances emerging from the record of the case over and above the averments and, if need be, with due care and circumspection, try to read in between the lines. The court, while exercising its jurisdiction under section 482 of the CRPC or article 226 of the Constitution, did not restrict itself only to the stage of the case, but is empowered to take into account the overall circumstances to the initiation, registration of the case, as well as the materials collected in the course of investigation. Take, for instance, the case on hand. Multiple FIRs have been registered over a period of time. It is in the background of such circumstances, the registration of multiple FIRs assumes importance, thereby attracting the issue of wreaking vengeance out of private or personal grudge as alleged. And I'm relying on this paragraph as well. On ground that these 3 FIRs and the manner in which the 3rd FIRs came
It's
into.
okay. To the
Second
extent of
citation.
filing multiple affairs, we can say, but it's not by the same person,
Second citation.
different
said-
person, but then you are not able to demonstrate how there is a personal grudge or to wreak vengeance. We are not able to demonstrate.
Very well. The second citation is,
What's the question of personal grudge?
my submission is that first 2
How
FIRs,
you,
after that,
how you demonstrate or establish a personal grudge? You had an agreement,
yes,
you have not honored it.
I am not.
You have
admitting to
played
the
a-
agreement, But purportedly there is.
thing.
agreement
So they have filed a complaint, I mean, the FIR.
there.
So
May I-
it doesn't,
Yes.
there's no question of personal grudge.
The second citation is,
Hopefully you will agree with me.
I beg to differ respectfully.
Then
2021,
if you differ, you demonstrate that there is a personal grudge. It is to wreak vengeance. You saw that, demonstrate it.
the agreement has been executed
Hmm.
with the company, first of all.
Ah.
I am the director.
Ah.
The co-accused is the director.
Ah.
Agreement says the complainants invested.
Yeah,
They did not entrust property.
Yes.
Money, but they invested.
but it says that you have
Even the clauses in the agreement shows that due diligence was carried out by the complainant and they knowingly executed the agreement. The concept for cheating is that there has to be deception at the initial stage when the promise was made.
It
When
agreement itself says you have received the amount.
It
Mr.
may
So and so has
it may-
received the amount so and so and so.
It may seem, but I'm respectfully attempting to show this court that the subsequent events which necessitated the filing of the 3rd FIR
Hmm.
shows that the agreement were fake. It has been planted intentionally to harass me and to wreak vengeance on me because of the cases in Delhi, because the property disputes are pending in Delhi at the moment.
What's the connection? Just show the link.
I
There's no link.
I cannot show the link at the moment, but it is the apprehension and the petitioner.
That is the reason. That's what I'm saying.
Then
Precisely, you are not able to demonstrate.
there's the question of the check also.
Not you may be, but your client.
There's the question of the check also. Account of the company was opened on 15/3.
That's why I said technically you may be correct, but legally, no ground.
Very well. May I at least be allowed to?
Let us do one thing, let this matter be fixed along with that your other case. Next Tuesday will dispose of the matter. I'll give you another chance.
These are all the documents which I have. I have filled them in all the 2 petitions, especially the 3rd petition.
I'll give you one more chance. Because this court is not inclined,
Very well.
not, not persuaded. As of now. So take some more time,
I'm obliged.
but I'm not adjourning it to for you to try before any other court. That's why I purposefully heard you for some time,
As you lordship please.
but I'm giving you a chance. Next week, which day? Same court. Tuesday, 19th. Will it be all right?
I'm obliged.
Maybe you may find out something more.
Right.
These are all settled
If
positions.
there's any connection.
These are the
I'll
old
try-
positions, settled
I'll
position.
get instructions.
We
from you.
cannot have any disagreement on this. It's a certain proposition that you have to connect with your,
I'll try
if you
to-
rely on para 26,
Yes.
connect the relation, the link.
Well, Since he's in custody, it's difficult for him to get extract information also.
So that
Is
could
it
be
the
a ground to
substitution?
adjourn the matter for 3 weeks.
But I'll try to take instructions from the client if he has any. Yes.
But I have not decided. This is my prime facie. So,
I'll take
all right.
instructions.
Mr. I, learned counsel to the petitioner. Also have, of course, I have not heard you, but we'll hear you on Tuesday. Mr. Yangami, learned public prosecutor. And also for respondent number 2. Have you heard? He's vehemently, he has vehemently submitted a list this matter on 19/9/2022 for admission. Better link.
I'll try to.
Can we list along with this matter?
That matter, it's at notice stage.
Ah,
If my learned friend is appearing for those complainants, those are the same complainants only.
a list
No, that's all.
this matter along with criminal petition.
Petition 15 of 2020.
We may segregate that day,
Yes.
we'll see
Okay.
what is there exactly. That is for
For
filing
the-
of the affair. Along with that, you give the number. Criminal petition. 22. Okay.
Orders item 32.
Office note dated 12/9/2023 reflects that the service report of notice upon the respondent number 2 is still available. List this matter after
I'm on my lord.
2 weeks. Huh? Mr. So-and-so for applicant,
Lost. My lord, 3 weeks.
3 weeks. This after 3 weeks. Yes,
This matter relates to civil dispute. Dispute is between two brothers, real brothers,
yes. Real brothers.
not eldest and youngest. Between eldest and youngest,
Eldest and the youngest.
not. Allegation has been made by youngest brother against youngest brother that
By the eldest brother,
eldest brother,
elder brother,
youngest brother.
youngest.
Youngest brother.
Yes,
Filed a complaint case before the CM court Kohima. Alleging therein that page 25 to 69, annexure number 1 is the complaint case.
page 25.
Page 25.
Yes. Alleging what?
That alleging that after taking money from him, youngest brother is not returning the same.
You are Mr. Upadhyay,
BK Upathi.
BK Upadhyay.
Basant Kumar Upathi.
Well, if you are real brothers, go back and settle.
Lordship, there is a.
Sir.
Lordship, kindly have a verdict.
Since you are
Honorable Supreme Court.
both of you are real brothers, what is
There
this?
is a citation lordship of Apex Court.
Lordship, the issue caught up in 2016.
Can you not compromise?
Yes, so much time has elapsed. On the part of the elder brother who I'm representing today, he has on multiple occasions, yes.
Your
tried
younger
to-
brother.
Yes, Your Honor.
Your own brother.
Yes, Your Honor. We are biological brothers.
What is the allegation?
Lordship, the allegation is that initially, a partnership, an agreement was reached in the year 2016 to,
Money dispute.
yes, Your Honor.
Go back. Hey, attempt, make an attempt.
Lordship, all the attempt.
I'll request both the learned counsel to be a part of the settlement.
Lordship,
Brothers, why unnecessary?
Your Honor, in spite of all our efforts, the,
By tomorrow, are they here? Are they here?
for kind information.
Are they here? Your client is here.
Lordship.
Yours,
yes, Your Honor.
Call them
He was
tomorrow.
here yesterday.
brothers, you settle it.
Lordship, for kind information.
You stay back today, sir, you stay back today. I'll request both of you to, we'll ask them to appear before this court tomorrow.
Lordship, just for the record, there have been so many occasions where we've tried to make amends, but it
No,
didn't work and there was a final straw.
Settle here.
Lordship, kindly for kind information of this court.
Yes.
My relative, common relative of ours, tried to settle this matter. But this elder brother is not ready.
What about you? Have you been involved for settlement? As a lawyer,
As a lawyer, I tried.
You-
But
you are the one.
he is not ready.
He's the
Lordship.
accused.
Um,
You are the complainant.
yes, Your Honor.
You are the elder brothers.
On our part, yes, we
See,
have apprised him of.
Elder brother has, as a big brother, you have to play the role of big brother.
Your Honor, records will show that as an elder brother, he has tolerated so much.
Sensitive to your younger brother.
Right, I understand.
You have to show the status of being an elder brother. Otherwise, why you should be called the elder brother?
Lordship, yes, I understand.
That's it.
Right.
Kindly consider.
Then on that basis, we'll decide the matter.
I think.
See,
that is not possible.
sir. Huh?
That is not possible at all.
So he's ready. Elder brother is ready. No. Why did you make an endeavor?
We have already exhausted all those
Wait.
on record.
What is the amount? How much of the amount?
The amount, Lordship, it's roughly adding up to 25 plus lakhs.
Doesn't matter. For brothers, you should be able to sacrifice a course. What type of elder brother you are?
Your Honor, I may be permitted to present my case also.
No. Before that, if you are to present, then we'll not talk about all this thing.
Lordship,
But you should, being an elder brother, you should play the role of elder brother.
Lordship, the facts are that I have not impulsively approached the court. There was so many things that was tolerated, and ultimately because of the
You should
lackadaisical
forget.
and yes.
That's what I'm saying. As a elder brother, you should forget everything.
Lordship, as per
I
the,
should not say all this thing. Parents are still there.
No.
See-
After death of parents, Lordship, he is the eldest brother. After death of parents, he taken the charge of whole family. And under his guidance, I have,
What of them are here
Lordship,
in Kohima? Your
Yes.
clan is Kohima.
Lordship,
yes, Your Honor, she was here yesterday.
eldest brother.
He
doing
Let's not make an endeavor.
Lordship, he travels often, so I am not aware if he is here today, but of course I can get that
We'll
information.
stop tomorrow. When you can come back?
Tomorrow,
Huh?
tomorrow, Lordship, I am here. I can stay here. Today. And tomorrow I can, but after that, Lordship, I have to go to Allahabad.
We'll take up at 2 o'clock. You make a phone call. You have
Lordship.
you just tell your client that the court desire to, settle the matter amicably and directed, requested you to, don't say, ask you to appear tomorrow.
Certainly. I'll,
Yeah, family disputes, elder
हाँ,
brother,
ये तो family dispute तो है.
then only on that basis will decide this matter.
Also, Lordship, see, the
Actually, Lordship, हमने पैसा अपने बिजनेस में लगाया, इनके लड़के को साथ में रखा, वो he supplies the all the items and I have given all the matter. 40 lakhs rupees, the item of 40 lakhs rupees I have
No.
supplied to his son.
if it is not possible to settle the matter, अगर नहीं हो सकता तो will the matter on merit? We'll try tomorrow.
Tomorrow,
You also
tomorrow, Lordship.
are Mr. B.K.
Deepak
Upadhyay,
Basant Kumar.
and also for learned counsel for the petitioner, and also had Mr.
Aziz Zakiri.
Aziz Kir, learned counsel to the respondent number 2. Mr. K. Angami for respondent number 1. You just first write K. Angami, learned PP for respondent number 1. In view of the nature of the case, this court deemed appropriate to request the learned counsel to the parties for settling the matter amicably as the disputes relates to, that is, it's a dispute between the real brothers. It's a dispute between is between the brothers. Mr. Accordingly, the learned counsel to the petitioner and the respondent are directed to ask the respective ask the petitioner and the respondent number 2 to appear before this court tomorrow. Okay.
Provided is
it
in station,
is it not permissible according to you?
certainly, Lordship.
Tomorrow,
Tomorrow
tomorrow.
at at 10:30.
10:30. First place.
But both of you do your homework tonight, so that we don't have to spend much time tomorrow. All right.
Okay. I don't know.
Yes.
Yes, your lordship,
Can you just refresh or recapitulate
yes, the
the
fact,
matter
yes, your lordship,
in a nutshell?
yes, the petitioner appeared the selection for teachers, primary, yes. There are two petitioners in the since there are two matters involved, what the petitioners appeared interview in 2009.
Graduate teacher maths.
Graduate teacher maths, yes. And according to the advertisement, 45%, those who are having 45% at the graduate level, they were eligible for appearing the exam. The two petitioners did not qualify, but the department allowed them to appear the exam. Now, as per the existing law at that point of time, there was no
Requirements of
requirement
45%.
of, yes, requirement of percentage.
It's
As per the-
45% is the about degree or the marks in the selection process.
No, degree,
Degree.
yes. So at that point of time, the central notification, that is the NCD notification, and as well as the state-based notification issued based on the central notification, prescribed no percentage for appointment as teacher. So after the advertisement, the petitioners were permitted to, as the petitioners were permitted, they submitted their applications
for appearing the exam, they were allowed to appear the exams. In the written exams, they were declared to have cleared the written exam. And they appeared the oral examination. When the oral examination was conducted, after the final results came out, when the final results came out, the posts to which they were subsequently appointed were shown as having no candidates. The other posts, they had the candidates, they were appointed, but the posts to which they were subsequently appointed, those posts were shown to have been without any candidates. So what happened subsequent to the result, the two petitioners again submitted applications and they were appointed against the posts which were shown to be having no candidates. Yes,
Other basis.
on a top basis.
Still you are continuing.
Yes, we are still continuing. Now,
The same post.
yes, in the
It
same,
has not been filled up
no.
by any other
No.
advertisement.
It has not been. Then what happened? The government by the approval, approved them to be, that they shall be appointed on a top basis with certain, subject to certain conditions that they should undergo the B.Ed qualification, training, and also as and when the tests are held, they will be based on the result of those tests, they will be regularized. That was essentially that was the approval letter. Based on that, they were appointed. Then what happened in 2017? Test was conducted. A test was conducted, and so they also submitted, since as it was circulated, they submitted their application for allowing them to appear in the test. What happened was, before the test was conducted, their names were by notification. Their names were not included in the list. Whereas other teachers and other employees of the department, they were allowed to appear at this, and all of them were regularized. So the petitioners agreed, have approached this court by way of a writ petition. WPC 132 of 2018, praying for regularization of their services. They had also, but when the state respondents filed their affidavit in opposition, they came forward taking the stand that they did not, because they did not have the requisite qualifying marks of 45% in their degree, they were not selected. That was the only ground. So this honorable court disposed of the matter by order dated 24/4/2019, where the direction to the state respondents to consider the case of the petitioner, considering that they did not have the requisite qualification at that point of time. The petitioner submitted representation again, it was rejected. Then subsequent to that, the petitioners came into knowledge about the existence of the the central government NCT notification and the state government notifications, which prescribes no percentage of mark for appointment as teachers. So based on that,
But it was in the advertisement.
it was in the advertisement.
Yes.
It was in the advertisement, but
So notification,
yes, the advertisement.
is it says that, is it, that 45% is not required, or it is
It is-
just
it is-
silent?
It is silent. That
Then-
means, it is silent, that means,
Then, sir,
your lordship,
you have taken,
it was silent, but then our contention is that since it was silent, because it was silent, we were allowed to appear the exam. We were permitted. In the first place, they ought to have rejected our application. But at that point of time, since there was that
No.
relaxation, they
They are-
allowed us to appear the exam.
See,
And also,
they are
our
great,
subsequent.
they are
Yes.
gracious enough,
Your
you
lordship,
have allowed to participate.
your lordship,
But when they finally for selection, they came to know that this, you don't have that 45% as per the condition of the advertisement. You are not
Your
appointed.
Lordship, then what happened was, they were appointed subsequently on the basis of the notification, that since there is no
Yeah,
qualification.
that's what I'm
prescribed, they were
saying.
appointed.
Government is so
Yes.
gracious.
But when qualification. has not been-
Truly a welfare state for you.
Your Lordship, it may be viewed from that angle also. It may be also viewed from that angle also.
Yeah.
From another angle, if it is viewed. There is no marks prescribed, and the advertisement is contrary to the existing.
So what is your prayer?
So my prayer is that since we were appointed,
For regularization?
yes, since we were appointed against the same vacancies which was shown to be without any candidate.
When you are
And
not,
then-
when you are found to be not eligible, why you have been appointed again?
That is the question, they have appointed it on the basis of the notification existing.
So I find your appointment is illegal,
So we were eligible,
Which
because we
cannot-
were found to be
which cannot
eligible.
be allowed to be perpetuated. Your appointment, you are not eligible. Will set aside your appointment.
Your Lordship, that would be
Too
a
harsh,
great injustice.
too
Great
harsh.
injustice, too harsh, Your Lordship. In fact, they have appointed the two petitioners on the basis of the existing notification. It is clearly mentioned, based on the notification, earlier notifications, then since they are qualified, they are appointed. Subsequently on ad hoc basis. And even the result, Your Lordship, the result shows that they qualified, even in the written. Those who obtained lesser marks than them, they were appointed. But
You got 38%.
yes, and those who got lesser than that, they were appointed. I have filed the affidavit also, Your Lordship.
This-
Affidavit, additional affidavit.
This one,
Yes, yes.
you
With
told me,
your
who have been appointed, who got the lesser mark.
Your Lordship will see page 15, Your Lordship. This is
This
the,
affidavit is for what?
this is to, just to bring on record the results.
Okay,
Which was not there.
that notification,
No,
press release,
the-
press release that you are directed to apply for this, what is called?
fourth, Your Lordship, the result also. The result of the interview, Your Lordship. The result of the interview, which we obtained, the result sheet which we obtained by way of RDI application, Your Lordship. And then the 2017 notification whereby we were omitted from, we were not allowed to appear the exam.
Though there is a press release to,
That was, it was, yeah, press release is.
it was for you.
Your Lordship, the next page.
Press release is for you. Is it for you?
Yes, for us, for all concerned, but along with the press release, they have issued the next page, that is page 7, Your Lordship. These are the persons who have,
No, just wait, before that, this page 6 press release.
yes, page 6 press release. This is to inform all categories of ad hoc employees. All categories. Your Lordship.
Including you.
Under, yes, it should include me, but because of the annexures. Because of the annexures, we have
Yes,
been
yes.
made ineligible.
Written test, huh?
Yes, written this,
What happened thereafter?
so we were, this annexure B was the one which was endorsed together with this press release, which excluded the two petitioners along with others.
No.
Page 7.
This, after this press release, what happened?
After this press release,
It was cancelled.
no, interview was conducted for the others, whereas we were excluded. We were not allowed.
Why?
This is the next annexure, Your Lordship.
Page-
Page 7,
Page 7, huh?
yes. Graduate teachers under SSA names to be deleted from the list of first submission.
How do you reconcile this? Whether this is in terms of this press release or not?
It was based on, it was issued together with this press release on.
Okay.
Yes. So we were not to be, we
You
were
are-
not
you are-
included in the list.
You are Robin assume.
Yes, we were not allowed.
Number three,
I am at serial number,
three,
yes, 3 and 7, Your Lordship,
7,
3 and 7.
lumber form, ah. Seven is Orang Kong,
Yes,
GMS Orang Kong, and you
Yes.
are in GMS Yang Chucho.
yes,
Yang Chucho.
Yan Chocho.
Okay. Then
So interview was conducted without us, and all those who agreed, they were all regularized in service.
okay.
Those who had been serving for around 3 years old, who came within the criteria. And we have been kept on a top basis till date, Your Lordship. Then we had applied for the copy of,
RTI,
yeah, by way of RTI, and this reply was given, the result sheet is there at page 13, the typed copy is at
there's 15.
page 15, Your Lordship.
Yours is
6,
6.
yes. So the
38.
lowest here is 37 and 34.
Ah.
So
There
there were 8 vacancies, altogether, Your Lordship.
38 in serial number 7 and
Serial number 6 and 7 have secured the same marks, Your Lordship.
who have been appointed below you.
And the one which is serial number 8, 37, he has been appointed, Your Lordship. I have taken out the extract from the result sheet, and I have stated in my affidavit, Your Lordship.
Where's the result sheet?
The result sheet,
Only one. 37, the serial number 8.
there were 8 vacancies altogether, 9
Okay.
of them got through in the written,
Okay.
9 of them. So out of those 9,
In the first petition. In the first petition,
no, in the exam.
Entire.
Written, yes,
including the second petition.
written exams. In the second exam, there was also one extra candidate was there who.
How many posts were there?
There were 5.
5,
Four votes. And
Four
5
posts?
have gone through.
including the mathematics,
Yes,
including the mathematics.
yes.
4 posts
But
here,
here,
first,
4 votes, here it is.
8 posts,
8 posts.
including
Under
the
this-
mathematics.
Yeah.
Huh?
Yeah,
One
This
post, one post for mathematics.
no, 8 posts of
8 posts
mathematics.
mathematics.
8 posts of
Okay,
mathematics.
here in second petition, 4 posts of mathematics. Okay.
So I have taken out the extract of I have typed the holding in the affidavit, Your Lordship, page 4. This is the result. This is the final result.
This for petition to, next petition,
Who typed this? I'm sorry.
huh?
Who typed this? What do you mean that? In the WPC, Your Lordship, the first case, Your Lordship. The final result is at page. Page 24, P2, election. Under serial number 3, Walker graduate, your lordship, in the last column, if you go down, the Walker graduates. In the middle, somewhere in the middle.
Okay. Yes. No, we'll come to next petition.
Yes,
The person who got less than you. K. Momo Kikon, 37. He has been appointed.
yes, your lordship.
Match.
And in the next case, the one who got exactly the same marks was appointed. Since there were only 3 posts,
Hmm?
if your lordship may go to my, in the next case, your lordship,
Hmm.
affidavit in 62. Page 14, your lordship. These are the marks.
You got 39.
39.50, yes.
Then who had been appointed less than you?
39.50, 39.50, and 43. There were 3 vacancies. So the person who received the same mark as the petitioner, he was appointed against 1 vacancy, and
One was kept.
yes, and
vacant.
one was kept
No,
because
nobody appointed.
yes, there was no vacancy beyond 3.
That's all.
Yes, your lordship.
So finally, your prayer is for regularization
Yes, regularization.
in view of the facts and circumstances of this matter.
Yes,
Because you are appointed on the,
against the same post.
again, the sanction vacant post,
Yes,
which was advertised.
yes. That is my humble submission, your lordship.
Since 2011.
Yes, from the date of our appointment on,
I
but
don't need two perfects.
2011 on.
Yes,
And
Levika,
Lordship, Brexit will continue
Okay.
to or.
will resume it too.
I have a citation to make, but
Your face is beautiful and your eyes are like stars. Your gentle hands have healing there inside the scars. Your loving arms, they draw me near, and your smile, it brings me peace. Draw me closer, oh my Lord. Draw me closer, Lord, to thee. The gentle hands have healing, oh my Lord. Your voice is powerful and captivate us, Lord Jesus. Set our eyes on you. Holy fountain, consume us with you and captivate us, Lord Jesus, with you. Your voice is powerful and your words are radiant bright. Devastate us with your presence falling down and rushing river, draw us nearer. Holy fountain, consume us with you and captivate us, Lord Jesus, with you. Your voice is powerful and your words are radiant bright. In your breath and shadow, I will come close and abide. You whisper life divine, and your fellowship is free. Draw me closer, oh my Lord. Draw me closer, Lord, to thee. And captivate us, Lord Jesus. Set our eyes on you. Devastate us with your presence, falling down and rushing river, draw us nearer. Holy fountain, consume us with you. Captivate us, Lord Jesus, with you. And let everything be lost in the shadow of the light of faith. And let every chain be broken from me as I'm bound in your grace. Set our eyes on you. Devastate us with your presence. Your burden. Your face is beautiful, and your eyes are like the stars. Your gentle hands have healing there inside the scars. Your loving arms, they draw me near, and your smile, it brings me peace. Draw me closer, oh my Lord. Draw me closer, Lord, to thee. And captivate us, Lord Jesus. Set our eyes on you. Devastate us with your presence falling down. And rushing river, draw us nearer. Holy fountain, consume us with you. And captivate us, Lord Jesus, with you. Your voice is powerful, and your words are radiant bright. In your breath and shadow, I will come close and abide. You whisper life divine, and your fellowship is free. Draw me closer, oh my Lord. Draw me closer, Lord, to thee. And captivate us, Lord Jesus. Set our eyes on you. Devastate us with your presence falling down. And rushing river, draw us nearer. Holy fountain, consume us with you. Captivate us, Lord Jesus, with you. And let everything be lost in the shadow of the light of faith. And let every chain be broken from me as I'm bound in your grace. For your peace, your burden is gone, your love wisdom, kind, right, and every eye will see you. And captivate us, Lord Jesus. Set our eyes on you. Devastate us with your flame falling down. And rushing river, draw us nearer. Holy fountain, consume us with you. And captivate us, Lord Jesus, with you. Captivate us, Lord Jesus, with you.
Maybe resolution, maybe please to mention item number 54. Hearing item number 54. I'm praying on behalf of my.
54.
5-4. Lordship, I'm praying for on behalf of my colleague, Lordship, Ajumli. Lordship, let the matter come out after 3 weeks.
MS Libica Landscape Council submits that matter may be listed after 3 weeks. Mr. MS. So in
3 weeks, Your Lordship.
Land Council for the petition has no objection. List this matter after 3 weeks for hearing.
Not too much. Notice, Your Lordship.
Yes.
Your Lordship, I beg to mention item number 49. Your Lordship, can you list this matter after 3 weeks?
3 weeks.
Yes, Your Lordship.
Petitioner.
Yes, on behalf of the council for the petitioner.
Ms. So Learned Council to the petitioner. So this matter will be listed after 3 weeks.
Yes, Your Lordship. Deeply obliged.
List after 3 weeks. Prayers are allowed, list after 3 weeks.
And Your Lordship, I beg to mention item number 41.
41 already mentioned.
Item number 41, Your Lordship. Can you allow me to withdraw this petition? I have instructions to do so.
Is it?
Yes, Your Lordship.
41.
Yes, Your Lordship.
You are for petitioner?
Yes. The council for the
Obviously. Yeah, Ms. So Learned Council for the petitioner submits that she may be allowed to, she has an instruction to, not to press this writ petition. Just to, come out, therefore, she prays for withdrawal of the writ petition.
Your Lordship, with liberty to file a fresh.
Prayers allowed. Then we'll have to say we did therefore praise for withdrawal of the writ petition with the liberty to file a fresh. Next paragraph. Prayer is allowed. Just accordingly. This writ petition stands clause on withdrawal with the liberty to file a fresh, if so advised.
Bless you.
Yes.
No, please, Your Lordship. Your Lordship, may I kindly draw your attention to the writ petition page 21 of Your Lordship, the advertisement. Writ petition page number 21
Page 21.
of the writ petition. Page 21 and share in.
Yes.
Yes, Your Lordship, as per this advertisement, Your Lordship, that is 20 November 2009. Your Lordship, by notification number EDS SSA CPA 09-2008 clause 1 dated 2010-09 and notification number EDS SSA CPA 009-2008-2 part 2 dated 2010-09. Purpose has been created, Your Lordship. Your Lordship, and Your Lordship, paragraph 1, graduate teachers on designation with qualification. Your Lordship, here it is written as a percentage of marks with Your Lordship. Your Lordship, here, under instance of Your Lordship, a person has been created and with the condition that like the person should have a qualification of BSc BCom, Your Lordship. BCom from a recognized university securing not less than 45 marks. That is the minimum qualification. Now, Your Lordship, the petitioner, before this called, they are not BSc, Your Lordship, but they are BCom with maths, Your Lordship. BCom with maths, and Your Lordship, we allowed them because there was requirement of teachers, Your Lordship, in certain areas, Your Lordship. Not only the petition, but in other districts also, Your Lordship, since there were requirement of the student, we make a relaxation that, okay, you know, those persons will have BCom with maths, Your Lordship. They are allowed to apply exam. Their qualification should percentage should be 45%. So that is mentioned, clearly mentioned in the advertisement. That is one thing, Your Lordship. Now, Your Lordship, if you can kindly come to 56, election one, on the mini comment, election one,
Just wait. It says BA
BC,
become, yes.
yes, Your Lordship.
In that case, they are.
Yes, Your Lordship.
eligible.
But mathematics mostly, Your Lordship, for maths, Your Lordship, usually science are taken, Your Lordship. But here we make a regular relaxation that BCom with maths can also apply. Your Lordship, now if you can come to election one, Your Lordship. Middle column. Election one on.
With it also says with BA. BA.
University.
45% marks with BA.
Yes, yes.
They are also having BA.
Also, that I come later again.
Okay.
But as far as this, the first person is concerned, I'll come with that later also.
45%.
Yes, 45%. In the degree course, they need to have a percentage of 45%. Your Lordship.
Yes.
Now, Your Lordship, if you can find on the same advertisement, edition one, middle column, Your Lordship. Serial number 56. 56 to 63.
Yes.
Got it, Your Lordship. Your Lordship, here 56 to 63 are concerned with Waka district. Waka district, and in the Waka district, under eight villages, Your Lordship. Under 8 villages, under the Waka district, 8 villages, in 8 villages, 1 place of knowledge is being advertised, Your Lordship. 1 place of maths, 1 place of science, 1 place of English. Now, the petitioner is coming before this court, making a submission that there was 9 posts, Lordship. And there was 8 posts, Your Lordship. 8 posts, only next. But here I'm making a submission before this court that each village there was only 1 post, Your Lordship. If you can see Waka type A, Sankik A, Yamchucho. Now Yamchucho is relating to the petitioner. Petitioner is relating this village, Lordship. So one village, one teacher of math was required and the place of math was advertised. And not submitted by the petitioner.
When you say one village, one post.
One math teacher is required.
8 villages.
8 villages, in 8 villages, one. In different villages, 1 math was required, and after column was each column. And in each column, 1 math was advertised, Your Lordship. That is required, Your Lordship.
Yes.
Yes, Your Lordship. So in all,
one village, one post.
1 post, Your Lordship.
So
Under Waka district, that is under Waka district.
for 8 villages, 8 posts.
Yes, Your Lordship. Now, Your Lordship. They were allowed to, Your Lordship, first relaxation.
That is what he has submitted.
No, he is stating that all
one village, 8 posts, he did say. He said,
under Waka, Your Lordship.
total under Waka, 8 posts of mathematics.
Which
Which would be according to, I mean, not according to, it's as per this, 8 villages,
8 villages,
1 each.
One each.
Post each.
One each. If Your Lordship has understood, then
8 posts
yes, Your
for
Lordship.
entire district.
Yes, if Your Lordship has
Waka,
understood,
huh?
if Your Lordship. Waka under Waka.
Please correct.
No, Your Lordship, what happened is that.
No matter, he has applied for one village.
Yes,
one
one
post.
village, 1 post, yes. Now, Your Lordship, what happened is that the petitioner, they were allowed to appear exam. Now, after
Why you have allowed them?
Your Lordship,
He is not having 45%.
submission application, there is no requirement. The Lordship, please find the beginning. You need to every time of submission, that requirement is not there. So the requirement was not there. Every time of Your Lordship, you have to be a record, you have to bring the mark certificate. But on assessment of the mark sheet, appointment is to be given, Your Lordship.
Can you show that in his application,
Yes.
he has played a fraud or something like that? He has concealed?
No, they have to go by the concept because I am already instructed that that percentage is not like in the column, Your Lordship.
Whether you have the 45% or not.
No, Your Lordship, there is you have to apply. So we, with a good faith, we let them apply, let them appear exam. That is the thing, your lordship, with good faith, your lordship.
You are on your part, government, you have daring also. You have contributed the illegalities.
There's a
Suppose the advertisement says 45%.
5%, your lordship.
Sure, while screening the application, there must be some column that you should mention 45% with BEd and all.
So
Anyway,
it's,
that's gone.
yes, yes. So your lordship, now after that, we let them appear in the exam. The petitioner, as submitted by the petitioner, they were called for interview.
Yeah.
I mean, now.
They have qualified in the written exam.
No, before that, your lordship, before the result was declared, there's a review meeting. If you can kindly come to the affidavit in opposition, your lordship. Affidavit in opposition, affidavit in opposition of the state respondent number 1, 2, 3, 4, and 5.
Yes.
Your lordship, if we can kindly come to annexure 1, page 7,
Yes.
column 5.
Yes.
May I read, your lordship?
Yes. Wait. Yes.
Your lordship, it's stated, at the final review of selection, candidates securing less than 45% of the ranks.
Where it is?
5, your lordship, column 5. So number 5, I mean. Your
Okay.
lordship. So number 5, at the final review of selection, candidates securing less than 45% of ranks at the graduation examination were cancelled. And the next candidate qualification was selected, your lordship. So this was prior to the final result, your lordship. Final result, there is a meeting, your lordship, and in this meeting, your lordship, it was result, your lordship. And this 45% was also in the advertisement, your lordship. And now before declaring the result, it is made it clear, your lordship, that these people who have secured less than 45 minutes, they graduate in the graduation exam, they were cancelled, your lordship. And the person who is securing, your lordship, they were selected, your lordship.
That means the person who has secured less than
45 marks.
No, less than the marks obtained by the petitioner has been appointed because he doesn't have the 45%
Yes, your
marks in the
lordship.
degree.
Yes, your lordship. Some conditions, it's like that, your lordship. So that is the condition, your lordship. Since the petition does not comes under the required percentage, your lordship, and therefore, your lordship, he was not selected, your lordship.
45% marks.
Yes, your lordship. Now coming to the result, your lordship.
Yes.
The petitioner has filed an additional affidavit in opposition stating that this serial number 1 to 9, the type copy, I would like to refer to type copy, page 15.
Yes.
Serial number 1 to 5 here, serial number 1 to 9. There is 8 pairs, 9 candidate was selected, your lordship. And now the petitioner is at serial number 6, your lordship. Petitioner is at serial number 6,
Yes.
he secured 43 point something, your lordship. And now the person
38 total.
38, yes, 38. His signature in the degree course, your lordship. That's 43%, 43 point something. Now at serial number 7, when we have appointed him as your lordship, he was given this with 49.21%. His percentage in the degree course was 49.21%.
Serial number 4.
Serial number 7.
No.
Interview we secured 38.
7.
Yes, your lordship.
K Momo Kikon.
Yes, Tom James Kikon.
Acha.
Yes, your lordship. He secured 49.1%, your lordship. So your lordship has directed that I should sort instruction on this in this regard. Serial number 8.
Not K Momo Kikon.
Yes, K Momo Kikon. She is he is also like secured 45 point something, your lordship. Then serial number 9, your lordship. Kohima himself, your lordship 34.50. She is from the and she secured 50.37%.
They've also appointed.
Yes, that's right. This is the appointed that your lordship, but statement number 5, that is the person above the petitioner.
Hmm.
And the trial or deal.
Hmm.
Your lordship, this person is secured 42. And he is much above the petitioner, but he was not selected because he also secured, your lordship. He also secured 44.25. That's why he was not selected, your lordship.
Serial number 5.
Serial number. Serial number 5. Your lordship, if you can come see the total that he has secured, 42. Secured 42, your lordship. When the petitioner has secured 38, your lordship. But the person who secured above the petitioner also was not selected, your lordship. Because he secured 44.25 in the pre-course.
Serial number 8 also appointed.
Serial number 8 appointed because he secured 45.something.
7 and 8.
7 also secured 49.21%. And the serial number 9 secured 50.37.
Then in that case.
Well, the person who secured 42 was not appointed, your lordship.
Okay.
42, your lordship. Can you note this one? Because this is very important. Because the person secured.
So the fact remains in one post remains vacant.
No, your lordship.
Johnson.
Your lordship, it's like this. I'll come to that, your lordship. I'll come to that. I'm just stating that there is no discrepancy, your lordship. Discrepancies have not been made. If you can see, your lordship, it is very evident, your lordship. I'm making it clear before your lordship. The person who secured the interview, both written and oral, and secured the kind of 42. That's why it's appointed, your lordship. Because we have 34.25, your lordship, in the course. So what exception has been made with the petitioner, your lordship? We have stated the 45, this person here secured 45% and the because we have cancelled. And it is evident from the record, your lordship.
The person who has secured
42
marks.
We have mentioned the petitioner also. So that is the thing, your lordship. Now, your lordship, after that, your lordship, the petitioner was not successful. That is the reason the petitioner was not successful. Now we made one relaxation also. Now, after that, your lordship, very important thing that the petitioner, after being unsuccessful, your lordship, in the interview, your lordship, he submitted an application for appointment, for ad hoc appointment. And now, your lordship, if you go to advertisement, if you go to the result, make petition again, your lordship. Make petition or page 24, and it should be 2. Page 24, and it should be 2. Yes, your lordship.
Yeah,
This is the
this was filed in 2002. Writ petition. I mean 2022.
No, this was filed in 2000. One writ petition was filed in year 2018, withdrawn, and now it was filed in 2020. After a gap of 8 years and 9 years.
Hopefully, this type of petition should not be filed now. No. The annexures and all these things has to be.
Yes, your lordship, yes.
That's why I'm asking. It was of 2020. Now, no more.
Yeah.
You'll have to check.
Now
we have to.
Now we have to go for paperless.
Yes. There it is true.
Because of you.
There it is true. I accepted it. Because of that.
We'll have a clear copy on the other petition, your lordship.
It's okay.
Your lordship, here, what I want to point out is that, your lordship, if you see Tuen Sang, Longlen, your lordship, in all these things, they were in total 23 posts of names, really like the person has not like percentage of 45%, and therefore, your lordship, it was not candidate. The petitioner is not an exception, your lordship. Petitioner found it an exception. If you can kindly see, your lordship, Longlen is an issue here, so I will not refer that. Tuen Sang, your lordship. On the lower part, on next portion, no candidate. Again, another in some law, next no candidate. Yellow if can refer to parent also. On cell number 3,
Where it is?
no candidate.
Okay.
Again, if you go down, Saijan, no candidate. Yellow chip again, long, no candidate. Yellow chip. And
It's okay.
yes, Your Lordship. So I'm making a reference here that it is not only the case of the petitioner, but it applies to all district cases, Your Lordship. But those persons who have not actually got the 45% in the degree course, then in that portion we have actually written as no candidate. So the petitioners are no exception in this case, Your Lordship. But that is one thing again, Your Lordship. So after that, Your Lordship, the petitioner, they submitted an application to appoint them, Your Lordship. So what happened is that, Your Lordship, the petitioner along with others, it is not the petitioners alone, Your Lordship, but others also submitted. So the petitioners along with others filed, they were sent to the government and the government approved and they were appointed under SSS scheme. Under SSS scheme. It is against this creation process, Your Lordship. We are really against this creation, but there was a requirement, Your Lordship, and actually he has not he does not possess percentage of 45%, and maybe he have a debate also, Your Lordship. But still we let relaxation to that extent also. And moreover, Your Lordship, we give appointment, we are generous enough to give him ad hoc appointment under SSA, Your Lordship. Now we can come to ownership 25, Your Lordship. That's the high grade, this is real 25, Your Lordship. That's the high grade, but the petition was
Yes.
So we can have the different as the high the appointment has come about. If you can have a question, Your Lordship.
Petition.
Yes, Your Lordship. It's not very clear, Your Lordship, but here, if you can come to terms and conditions. This person are a person who have a qualification of and we secure 57 and 47 from respectively, and very successful. And then a lot of the terms and conditions in the high level. The key analysis of the appointee shall be made by the state commission authority. That is very important. The second one, even a brief determination of SSA program, then shall be done by the state. Your Lordship, it's very clear, Your Lordship. And so for this how Your Lordship, those who have applied the exam against the prosecution and will be successful in the exam, they put some condition that their analysis will be done by the SSA, and this continuation of SSA will be analysis will be done by the state. Now come to the appointment of the petitioner, Your Lordship. Now, if you can come to the appointment, Your Lordship. Page 30, Your Lordship. No. Page 4, serial number 4. The appointment is pure on ad hoc basis and to we have to only board. Your Lordship, the petitioners were appointed on a fixed pay, Your Lordship, on a fixed pay. You got it, Your Lordship?
Yes.
No, Your Lordship, the petitioner was appointed on an ad hoc basis with a fixed pay of 8,500 per month. Your Lordship, after that, Your Lordship, the petitioner again filed the petition before the court, Your Lordship. And with that petition, they claim that their salary should also be enhanced. And accordingly, the direction of this required, Your Lordship, their salary was enhanced to 27,000, Your Lordship, and we accepted that also. Your Lordship, I would like to place that record also.
Just wait. Where do you get it, 8,000?
8,000 is at the, beginning, actually, the beginning. The,
Okay,
you got it, your lordship. 8,400 per month, fixed pay, your lordship.
but the fact remains that they are still, they were appointed on those posts only,
Yes, there.
sanction posts.
You this is not your lordship. He does not have a percentage. He does not have a beard. He does not need to go for beard. Because your lordship, you have such a student, we need to get a quality education. So the reason that we allowed him to go for beard, that's why he is saying that when I'm allowed to go for beard, that's why I should be. Is that a question?
Cancel the appointment or?
Yes, yes.
You cancel the appointment.
That's how we can issue the advertisement again. So if he's not willing to take this appointment, if he's not willing to continue, then it should be a less willing to advertise his post.
That, how can you allow the person to continue on ad hoc basis at a sanction post?
No, your lordship, one thing is that your lordship, in this area, like there was no requirement at that point of time, your lordship, your lordship, like I understand the scenario, your lordship. At that point of time, there was no person with a qualified degree or like having a required qualification, and the students are there, your lordship. And so, your lordship, we feel that there is a requirement for teacher.
More than 10 years, they must be having a good teaching experience by now.
Yes, your lordship, but see, we have achieved advertisement. But when we could make because we have advantage. Otherwise, we have actually repeated all 2011, 2012, 2013, advertise, your lordship.
This post.
So we could replace your lordship.
Forget that. This post, we're talking about this sanction post. This is sanction post.
Yes, your lordship, because we are not to continue and we are not to.
Why not another illegality? By regularizing them in the interest of public.
No, your lordship, we cannot regularize because they are people on SSA, your lordship, and they are hundreds of SSA, your lordship. Hundreds of SSA, the notice limit, the majority of the Supreme Court.
SSA, how can this be a sanction post in that case? If it is SSA.
As I have stated earlier, your lordship, as this post was created, and SSA, your lordship.
Yes.
Your lordship, this qualified as stated in the and this continuously
continuing or it's a SSA is still continuing.
now it has become Samagra, your lordship.
Okay, so they are in under Samagra.
Now they are under the streamlined last year only, your lordship. Last year only, although all of them has been streamlined in the state cadre, your lordship.
State cadre.
Yes, your
That is
lordship.
the problem.
No, but how come? Because this is not qualified, your lordship.
No, but then by your action shows that they are required and they are allowed to continue more than 10 years in a sanction post.
No, your lordship, they come to see your lordship. This was a person who the condition of the petition. Qualified to be the petition, your lordship, and
Should include that advertisement.
please, sitting advertisement, your lordship.
You have not allowed them to. Yes.
To continue your lordship. And not the petitioner after entries and money before this court. They're not challenging this advertisement, your lordship. No, your lordship, without challenging this advertisement also, your lordship.
No, that's why issue, we agree that as a matter of, as a matter of right, he cannot challenge, ask for regulation on the basis of that advertisement. But then you have allowed him to, you have appointed him to continue in the post, in the sanction post more than 10 years, now 12 years. You regularize their service.
No, your lordship, that because it's purely like your lordship, it's purely SSA, your lordship.
This has been streamlined. Last year, it's become a state cadre.
No, there's a difference here, your lordship. Petitioner also agreed in that post, Your Lordship, he did not qualify.
If those who have been appointed and qualified and appointed,
Yes,
it
Your
has
Lordship.
been streamlined and brought to the state cadre,
Yes, you know, because qualified, Your Lordship, not petitioner.
not that post.
No, not the petitioner, but for me to be for me to agree and then who is being very central in the. It's a different issue, Your Lordship. Because you're agreeing on flagship, Your Lordship. So you're like, someone says, okay, we will replace them. We don't have any on that. But now, Your Lordship, there's so many of the analysis I do is being done by the central. And how can the central interplay, Your Lordship? Is it possible, Your Lordship?
Why you
The analysis is done by the central, Your Lordship.
have appointed them?
This is what I'm saying, Your Lordship. So, I think it's strong, the but here, the election, and successfully, and then he's making a video, and want to take another benefit election, is that permissible in the next election? So I would like I to consider your lordship. He's been unsuccessful first and foremost. Your lordship, he doesn't have eligibility criteria, percentage criteria, your lordship. He doesn't have a beard also. Your lordship, and then he's like taking the string of advertising and speaking that I should be regularized.
Though it is a sanction post, it is under the summer grant.
Yes, I'm not going to see the we are next willing to advertise this person at this point also, but to continue just should us in fact, I don't see a relative, but you are to advertise your lordship. Nobody wishes now.
Who is stopping you?
No, that's why you need to put a lot of prevailing the
Who is stopping you from discontinuing their service if they are not and just because he's seeking say regulation, you cannot again terminate and discontinue their service.
That's right, Lordship.
You have not done so, you have to consider it.
Yes, again, that period, sir. We did consider one for the
One more act of generosity.
You actually your lordship
again.
Now, what option do you have, your lordship?
Regulate them.
You actually rejected that. He has not checked that also. He has come with another speaking another stream of advertisement. The lordship will not clear in the representation, your lordship.
Yeah.
But we feel that the representation also. You should have come actually before this court, and then you got
the regulation, I mean, the rejection.
Rejection, your lordship.
Representation.
To my affidavit in opposition. Your lordship, annexure 7, page 18 of my affidavit in opposition. Annexure 7, page 18, your lordship. It's crystal clear, your lordship. If you can kindly go to, if you allow me to read, your lordship.
Page.
Page 18, annexure 7. The petition is also enclosed, but it's not clear. That's why I'm waiting for my affidavit.
But he's not challenging it.
No, your lordship, he has not challenged it. In fact, now he has come, you know, not challenging this one, he has come before it's called the string of advertisement, your lordship, and he has not challenged also, your lordship. And there he has not been successful. Now the question of not giving regularization is already decided, your lordship. The government has already made it clear that we cannot give regularization. Now how can we consider him when his petition has already been, representation has already been rejected?
But then there's no bar direction from this court.
Your lordship, there is no bar, your lordship, but we still rejected the answer is very clear, your lordship. That's up to the court, your lordship.
You have prejudice.
Of course, your lordship, we go from our words, your lordship, it's very clear.
Okay. Yes. Obviously, is wise enough because there's a judgment of this, you have quoted the judgment of the Supreme Court. So obviously, you not challenge this, your rejection order.
Yes, your lordship, my only case is that since they were again appointed against the vacancy and they had also in the examination cleared the exam, at least they were selected, but because of their not having the 45% mark. But at that relevant point of time, no percentage was prescribed under the rules. That is the only case. So now, since they have been appointed against the same post.
Was it was not prescribed or it was omitted to, it was silent?
It is silent, but now.
If it is silent, they have the.
Yeah.
Prescribed.
It's not but for.
Opinion, I would like to place a judgment of this division bench in a Manipur case. It was also a.
No, your place, you can place anything.
Yes.
Not only Manipur, you can
Yes.
place any.
These are
judgment which you
relevancy
are
here,
trying.
and so, an exam.
No, I think it's,
Just a
you have not,
particular paragraph,
have you
yes.
complete?
Your lordship,
One,
and now your lordship, the petitioner is harping your lordship on the notification issued by the central and, but the central law is silent on that, your lordship. And where is the bar, your lordship? Is there a bar in on the central law? The law, this cannot stop any percentage. It's not satisfied the court. Is there a bar? If there is a bar, okay, your lordship, we surrender. There is no bar. The lordship, it's not that the state has every right to prescribe the minimum percentage, your lordship. And prescribing the minimum percentage, your lordship, it is to education to the your lordship. And the petition is to the 3%, your lordship. So your lordship, we are.
practically, there is a difference.
Yes, your lordship, now.
Obtaining marks in exam
Yes.
and having a quality of it all we see in
Yes,
in our fraternity also.
Your lordship, however, your lordship.
Yeah, you may got 80%, but those who just qualify, 33% also better.
Yeah.
Lawyer than those
Yes,
who
sir.
person have the 80% also.
Your lordship,
Scoring a mark, it
Yeah.
doesn't, of course, I'm not saying that you cannot prescribe.
Yes, sir.
You may prescribe, but
Yes,
it
sir.
doesn't mean that the person having a good marks, it's not always a
yeah, definitely, I agree with that, but now,
good teacher.
so lordship, but now,
Now you have allowed them for more than 12 years. You should consider.
it's very lordship, we should consciously say when that wrong, your lordship. Not going for the situation, start with them, then we can be left with no option, to replace his place and the process of the case. That's it, your lordship.
Indirectly, he's saying, don't dig your grave.
No, that is the thing, your lordship, that is the solution we can bring.
The problems of the petitioner, they are kept hanging, your lordship. That is the only.
No, your lordship, how can you make an exception to the petitioner's case, your lordship? Is there a way to do it?
Central government notification, whatever is there,
Yes,
what
sir.
is that?
There is silent, it's silent. your
Since
lordship.
it is silent, you have the authority to prescribe any condition.
Yes, your
In the
lordship.
advertisement.
Yes, your lordship.
Okay.
So, to give quality education, at least a minimum description of percentage is required, your lordship, and accordingly, we have done that, your lordship. So, your lordship,
That is the basis that if person having less than 45% in the degree will be a bad teacher.
no, your lordship, that would be outside of the record, so your lordship, I will not delve into that. We'll just confine to my advertisement, because my advertisement clearly stated is 45%, your lordship. So, your lordship, and he has not challenged that, he's coming after 8 years, after taking all the entrance and he can pick again and taking the string of advertisement, and he is not challenged that advertisement.
The advertisement, all these things has become, it's a fait accompli.
Yes, your lordship.
We may not delve into it, but then your action also saw something
As far as our action is concerned, I'm very clear on it. No, Your Lordship, we are completely satisfied.
Yes, satisfied yourself.
Yes, Your Lordship.
But the court is not satisfied.
Like that. That's why we are satisfied.
It's a universal thing. Every action of yours, it's his own action always satisfied. By your own action, you will be satisfied.
Worship, I'm trying to satisfy Your Lordship. So, Your Lordship, now, Your Lordship, the eligibility test was actually given out, Your Lordship, where the petitioner has been rejected. Why, Your Lordship? Because that eligibility test was only for those person who were serving as a understood cadre, not the person who are serving under SSC.
This press release.
Yes, Your Lordship, and therefore they will not allow to pay as President's Your Lordship.
How do you say? How?
Your Lordship, there is one President, Your Lordship. I would like to place it before Your Lordship, Your Lordship. If you can kindly allow me to place, Your Lordship, one document, Your Lordship.
No, first you read this press release. 2nd May 2017.
Which one, Your Lordship?
Page 6 of additional affidavit.
Page 6. Yes, Your Lordship, this press release was given, Your Lordship.
For those state cadre.
Yes, Your Lordship. It is actually, this press release is only meant for those who are serving in the state.
That's why I'm asking, how do you find that?
Your Lordship, this is to inform of all categories of advocacy under the Directorate of School Education who have completed 3 years or more or continuous service conducted on 28/2017. And on so and so, Your Lordship, written test will be duration of 3 hours. This will be issued by the School Education, Your Lordship. It is not related to a scheme, Your Lordship.
So this is not for the.
Not for
teachers
SSC.
who's
SSC.
working under the
School education, Directorate of School Education.
according to only Directorate of School Education.
Yes, Your Lordship. And now,
They are not under the directorate.
Your Lordship, they are under SSA, Your Lordship. They are not an SSS scheme, Your Lordship.
Is it?
Yes, Your Lordship. Is the meetings? SSA scheme.
Your Lordship, the education department,
Take care of it, but SSA is
the
under,
umbrella,
it's under the
it's a
umbrella.
main body.
Huh?
The education directorate, the education department. is,
Director of School Education is not
Yes,
under.
It's the umbrella.
in charge, Your Lordship. They have,
So it should be included.
Yeah.
It's not also.
Your Lordship, this, why I'm saying this is that, Your Lordship, this, press release, it's not included, it does not include the petitioner, and therefore they were rejected. Your Lordship, this also. This is not an application. This is a for complete 3 days. And what office this person we are seeing the state cabinet for the state and service and the service for English not challenging that only. And now that I need his state lordship. It is this time, our lordship, we went to this, which the Supreme Court, this lordship. So now, I believe that, which is appealing to the court, covering this number of them. Because the Supreme Court has already done that earlier, citing another this case. Now the petitioner here, the not given us that cover for that reason, but now in SFA. Now, how do you allow them to go, get regularization? At least for that period, we have that provision in lordship. Only when I say 1 AM stating that this person will be appointed on a block again. For 3 years, the bank is servicing, at least for 3 years, we will allow them to, be for eligibility.
So
That's has been staged.
according to this press release, this doesn't
Cover the case of the.
petition. It's all for state cutter.
So lordship.
Okay.
And now for this also it is normal evidence to respect the rules now.
What?
And because I've heard that this space was removed with the issue to lordship. But if that covering, you was going to 2 years continue forward, we can everything this and we can be legalized. But now that even because of this case, it has been the eligibility has been revived. So now, when we legalize the state covering, how can we allow an exception for the petitioner and the service being serving under SFO? That is the question, Your Lordship.
But that case is that 2016.
It was decided yesterday, it was decided.
2016.
Yes, Your Lordship. I am not able to remember, but I can find it that one also. Because this court decided the matter, it went for division bench, the division bench rejected, and it went for it's court dismissed.
Maintainability.
Yes, Your Lordship.
So, but then we have come across this morning. Of course, only notice has been issued. That in view of the disposal of those matters,
Yes.
where the stay was there
Yes, Your Lordship.
of the office memorandum.
Yes, Your Lordship.
According to Leonard Senior Counsel, it merged with that order. The writ petition has been disposed of and is dismissed,
Yes, Your
so it revives.
No, how can, Your Lordship, that, Your Lordship, since that.
Whereas after-
Yes, I don't, Your Lordship.
After the interim order of this court in those cases, in 2018, there was a circular not to process because of the stay order on the office memorandums. Then that is put to challenge because after all this disposal of this writ petition
Yes, Your Lordship.
and the writ appeal and Supreme Court, whatever,
Yes, Your Lordship.
it merged along with this, the interim order merged along it. Meaning thereby, the office memorandums again revived automatically by operation of law. According to the,
No, Your Lordship,
Petition. we have issued a notice on that.
but that matter, Your Lordship, since I'm not conversing with that case, that basically in that case, I can.
You find out, you may not be personally dealing with the matter. Mr. Angami was, N. Angami was appearing.
Maybe, might be, but Your
You
Lordship.
find out because it
How can we revive when there is down on
it
the.
will affect the certain cases. And
Yes.
if it is not, of course, if it is not brought before the court, we may pass conflicting judgment also. So you have to be very careful on this.
Yes, Your Lordship.
Maybe different, your colleague must be handling the matter. But then it's your duty also find out,
Yes, Your Lordship, but that is okay.
so that it can be, you can properly assist the court.
Yes,
in
Your
other
Lordship.
matters, related matters.
Yes, Your Lordship.
So it may be have a bearing on it, but then for this matter, but you have to sure.
Your
Because
Lordship.
once on the basis of interim order, you have the office memorandum,
Yes, Your
there was a stay,
Yes, Your Lordship.
and finally it has been dismissed,
Yes, Your Lordship.
the writ petition. Up to Supreme Court dismissed.
Yes, Your Lordship.
So,
Upheld, Your Lordship, the judgment of the lower court,
uh,
of the single bench, I mean, Your
single
Lordship.
bench.
Yes,
So single bench has stayed those memorandum.
Yes, Your Lordship.
So that has been dismissed. Writ petition has been dismissed.
Yes, Your Lordship.
You see, interim order marched along with the disposal of the main petition.
Yes.
So that is what they are saying.
Lordship, to that extent, Your Lordship, maybe that will have a difference on that, but no, Your Lordship. Here the petitioner, Your Lordship, they are not even a step cutter for one thing. Your Lordship.
Why I'm pointing out,
Yes,
because
Your Lordship.
you are saying that even that office memorandum is no longer there.
Yes, your lordship,
When-
some of it in a portion.
Policy was that those person state cadre who is who has served continuous 3 years
Yes, your lordship.
can be regularized.
There's a, that was state.
State cadre, this has been stayed by the.
Yes, your
Which is
lordship.
no longer there. The policy is no longer there, according to it.
No,
In that context only, I'm just pointing it.
yes, your lordship. Well, I think I'm pretty sure, I think the government, like, since our colleague is appearing, I think we will.
Not only notice, I have passed an order, the pendency of the writ petition shall not be a bar to consider the case of the petitioner.
That, your lordship.
So you will have to be, you discuss with Angami.
Your lordship.
If according to you, if the policy is no longer there,
Yes, sir.
according to you,
Yes, sir.
that will be that order will not be a proper order.
Because still now, we are not taking anything on that, your lordship, because that has been done by the Supreme. But even otherwise, your lordship, what I'm saying is that the petitioner is not even a state government, that's why your lordship. It's just kidding.
Okay.
That's why the question of this regulation does not arise. And now there's so similarly situated with the petitioner's case. Your lordship, some of them in the Supreme Court, they have never prayed for regularization. They are just for applying for the enhancement amount of your lordship. Because they would not be like, it's not the question of regulation does not arise for the lordship. That's not the lordship. Now, can we make an exception to the petitioner's case?
Supposed to place that order.
Yes, your lordship, if you allow me, I will actually place it, your lordship. Yes, sir. And therefore, your lordship, I think the petition case does not survive, your lordship, and likely to be dismissed, your lordship, I also been your lordship, on the issue of advertisement, your lordship, I want to place it. The first one is 1991 supply clause to Supreme Court.
Yes.
Yes, your lordship, Municipal Corporation of Greater Mumbai and others versus Dr. Shishir V. Patkar and others. Your lordship, since it's a very short order, your lordship, and I mentioned your lordship, it's a very short order. Third counsel on both sides, the eligibility for appraisal was the candidate was qualification. The length of the qualification was in place on which date and qualification. Please take out qualified. So, the certification that he is but the qualification in question. If I did not follow the stage and have the selection rated the selection book complete the selection and render the qualification. We still understand the qualification of the high court how do you depart from the decision to the question? For the 15, the decision of the qualification for selection, having come to finish the qualification acquisition qualification. State the selection. This for his defense. The selection then was mentioned what to was indicated and to satisfy the condition of the certificate of everybody necessary qualification. He did not to say that he should be in the selection. The abstract need is to admit from the price of charges. We are going to think is for in defense of Article 36 of the Constitution of India.
Have you given an opportunity to produce the eligible certificate?
This is very clear. We are not clean. Your lordship, and clean your lordship. Your lordship. For example, on the review, your lordship, since his percentage was not as per the advertisement and therefore your lordship.
If the rule is, if the rule or whatever,
Yes, sir.
the memorandum, office memorandum or policy of the state is silent
Yes, sir.
regarding the percentage of marks or the qualification.
Yes, sir, lordship.
If it is silence, the authority can prescribe the minimum qualification or marks.
Your lordship, to that matter, your lordship, you need to give it time for me, your lordship, to.
That is the issue.
You know, that is the issue, but how your lordship.
That is the point you have raised.
Yes, your lordship, one thing is that what we should arrange the.
You should come up with a judgment
Yes, sir.
to which supports your points.
Yes, your lordship.
Don't come up with a judgment. Not there.
No, your lordship, I'm saying your lordship, the person, because he has not changed the advertisement, also your lordship. He has not challenged an advertisement where it stated that your lordship, it has money for the 45% your lordship.
Okay.
But we have not challenged the advertisement, your lordship. We have not even challenged representation, your lordship. Why he has been rejected, why his representation is rejected when has been rejected. But we cannot be considered for regularization. He has not challenged that one, your lordship. So that is the reason, your lordship.
Next.
Your lordship, next is your lordship, 2019.
Yes.
Your lordship, it is with regard to your lordship, advertisement, your lordship.
Yes.
High Court of Hyderabad. The relevant power will be, your lordship, 15, your lordship. It will be your lordship 13, 14 and 15, your lordship, but 15 your lordship in order to save the time, your lordship. When I mentioned that the High Court is right to the extent that the point to be read in terms of stipulation content in the advertisement, your lordship.
Which one? Page
Around 15, your lordship.
15.
Your lordship. Around 15. Got it, your lordship. So it talks about the stipulation in the advertisement. So your lordship, it has to be, the advertisement has to be adhered to, your lordship.
No, but this is a case up to the
facts is like your lordship, it's.
You have changed the criteria in this matter up to the advertisement
Yes, your
on that context only. This is changing the rule of the game. There has been, I think, Mr. Akito, it has been, Supreme Court has recently made an observation that has to be revisited.
Yes.
Changing the rule of the game principle.
Post the advertisement.
So in the, according to you, by this,
No, your lordship, what?
the stipulations or the where the criteria was sought to be changed after the advertisement.
But it's not the principle, I'm thinking of the principle only, which is the lordship, but I'm thinking of the principle only. The advertisement lordship has to be adhered to your lordship.
Obviously,
Yes, your lordship, that it is also severe, your lordship.
2018.
Yes, your lordship.
Then this is para.
Your Lordship, para 16 will be relevant, Your Lordship. The advertisement was not challenged, Your Lordship. Para 16 will be relevant. Yes, Your Lordship. So, Your Lordship, even if you have to take the string of an advertisement, Your Lordship, the petition has not challenged that one. Your Lordship, firstly. Secondly, Your Lordship, the petitioner is asking for regularization based on the date where he was appointed on ad hoc basis, Your Lordship. Your Lordship, but his case cannot be considered, Your Lordship, and that has been actually replied to by the representation. And therefore, Your Lordship, we cannot consider because he has been appointed under a scheme, Your Lordship. And therefore, Your Lordship, the question of regularization does not arise, Your Lordship. And so, Your Lordship, the petition case should not be considered. That is my prayer, Your Lordship. Yes, Your Lordship.
That's all.
Yes, Your Lord.
But your main submission has not been supported by any judgment.
Your Lordship, by where is that, Your Lordship?
This is
Advertisement, Your Lordship.
advertisement.
Your Lordship,
Knowingly he has appeared, and on being found to be unsuccessful, he cannot turn around and challenge the advertisement.
Your Lordship, no.
Or a selection process.
Yes, no, but no, Your Lordship,
It is not dispute that he is not challenging the advertisement. He just said it was not a requirement.
yes, sir. Now, if the,
Basically, he is not challenging the advertisement. He said it ought not to have been, but then in any case, I've been appointed on ad hoc basis. I should be regularized, that's all.
no, Your Lordship, if you have to focus on the advertisement, you have to give us an answer. I can furnish the evidence as to why the person who are opening in the scheme should not be regularized, Your Lordship, because so many things, Your Lordship, and then, Your Lordship,
That is the one you should have come.
Your Lordship, I'm sure the petition was hardly on the advertisement only. Your Lordship, and that's why or if it is being drafted and line on the Your Lordship.
Aspect, but
Yes, Your Lordship.
what is his prayer?
Yes.
In view of all this, I should be regularized, direction should be to consider for regulation from the date of his appointment.
That's why Your Lordship, we also replied, Your Lordship.
Public substance, basically, he wants a regularization. So your case is, since he's under the scheme, could not have been regularized. There's no question of
Your
regularization.
Lordship, I can submit it tomorrow, Your Lordship. As far as those persons are appointed on ad hoc basis under a scheme cannot be, regularized, that I can submit tomorrow, Your Lordship. Because doesn't admit it fact, Your Lordship, that he is being appointed, Your Lordship, under an SSA, Your Lordship, under a flagship, Your Lordship.
We'll just see, here is reply. Quick reply. Huh?
Your Lordship is giving her time to reply to.
She has completed.
Okay. Your Lordship. I'll just-
Quick reply, 5 minutes, 5 minutes.
I'll just submit one decision.
Ah.
With regard to the laying down of the percentage, when the rule is not there.
Yes.
Only on that aspect, I'll just. This is 2000,
But
17
in that
GLT.
case, you have not challenged the recruitment.
I have not, but if it is a nullity, if that percentage thing is a nullity, then I need not challenge it, your lordship. That is the only case. If it is null and void, then the question of challenging it does not arise. I am not aggrieved by the interview, so I need not challenge the whole.
Your lordship, it's not involved. All those persons have been appointed. How can we?
With respect to the qualification,
How, your lordship?
only with respect to the percentage, only with respect to the percentage, your lordship. That is the only case.
Okay,
Your
okay.
lordship, your lordship.
Proceed.
Yes, yes, this is 2013 to GLT 131. This is division bench judgment
2013,
2013 to GLT 131.
131.
Yes, your lordship. This is also related to similar case which is similar, but law of light is same, your lordship. Page para 27, your lordship, we will start from para 27.
Para 27.
28 and 29, I'll read, your lordship.
Yes.
27. If I may read, your lordship. Page 144.
144.
144.
Yes.
It is well settled principle as referred by Mr. Singh, learned senior counsel, that the recruitment in the government service must be carried out in terms of the rules framed under the relevant statute. Instead of Uttaranchal versus Alok Sharma and others, as reported in 2009-7 SCC 647, the apex court held that the relationship between the respondents herein and the said government companies was that of employee and employer. The companies under liquidation, although were incorporated and registered under the Companies Act 1956, they are state within the meaning of Article 12 of the Constitution of India. As state, therefore, they were bound to comply with the equality clause contained in Articles 14 and 16 of the Constitution of India. In terms whereof, cases of all the eligible candidates for appointment were required to be considered. Recruitment in government service must be carried out in terms of the rules framed under a statute or the proviso appended to Article 309 of the Constitution of India. Number 22, keeping in view the principles laid down by the Constitution Bench of this court in state of Karnataka versus Uma Devi, there cannot be any doubt whatsoever that any condition laid down in any rules which is in derogation of all the recruitment rules framed by the state should receive strict construction. 28, instead of Orissa and others versus Prasanna Kumar Sahu, as reported in 2007-15 SCC 129. It has been held that the policy decision is subject to the statutory circumspection. The state is bound by the constitutional scheme to treat all persons equally in the matter of grant of public employment, as envisaged under Article 14 and 16 of the Constitution. The policy decision taken by the state in exercise of its jurisdiction under Article 162 would be subservient to the recruitment rules framed by the state, either in terms of a legislative act or under the proviso to Article 309. A purported policy decision issued by way of an executive instruction cannot override the statute or statutory rules, unless the constitutional provisions in Prasanna Kumar Sahu, the apex court held as under. It is now well settled that the state is bound by the constitutional scheme to treat all persons equally in the matter of grant of public employment as envisaged under Articles 14 and 16 of the Constitution of India. Even a policy decision taken by the state in exercise of its jurisdiction under Article 162 of the Constitution of India would be subservient to the recruitment rules framed by the state, either in terms of a legislative act or the proviso appended to Article 309 of the Constitution of India. A purported policy decision issued by way of an executive instruction cannot override the statute or statutory rules, far less the constitutional provisions. 29. Any appointment made in violation of the prescribed qualification laid down under a statute is a nullity. The apex court in Mod Kumar versus
Okay.
Education. So what essentially is stated is
To say.
that the statute, the rules is silent on the issue of.
What does it say?
No, here in this case, the statute does not prescribe any rule. Any provision
So
for
therefore,
enhancement or reduction.
therefore,
So-
according to you,
Yes,
prescription of the conditions,
yes. By the directorate,
which is silent in the statute.
yes. It is silent in
It
the
is
statute,
nullity.
so, yes, it is a nullity. It was not on the basis of the, it was not on the basis
If,
of the,
if it is in violation of the statutory provisions,
yes.
what is the statutory provision?
The statutory provision when it is silent.
Where it is?
Now, your lordship, the provision,
Which provision?
if it is a statute,
Which provision? That national
yes, NCT
NCT.
rules, yes, NCT, yes,
NCT rules is
Yes.
silent,
yes, it is silent,
but it says in
Yes.
violation of prescribed qualification.
yes. Prescribed they have given prescribed qualification.
Suppose rule provides 45%.
Yes, then in that
If you appoint
then it will be.
those person who is not
nullity.
having the 45%,
yes.
that will be nullity.
Yes.
But here in this case,
Yes,
the act is silent.
yes,
There's nothing, this thing has been
Yes, you're right. Yes.
prescribed.
yes,
But in the advertisement,
yes.
it provides. So it cannot be said to be nullity.
No, advertisement has to be in terms of the act, your lordship. That is my only ground. That is my only.
That's what?
The act provides that it is any graduate can apply, any graduate can be appointed. So when the act clearly says that any graduate can be appointed, they cannot limit that by way of issuing advertisements.
So
All they can do is they have to incorporate it by way of amendment or necessary, yes.
they are bound by the state,
Statutory,
that
yes.
national, what do you call? NC,
Yes, NCT,
NCT.
yes. Even in this judgment at the end, the learned division bench has held that the Teachers Education, the Children's Education Act, which was passed by the Manipur, was in violation of the NCD, and since the central rule,
What they have prescribed?
they
In
had
this case,
They had made. Actually, the central government has given relaxation to the government. Because when the Education Act, Right to Education Act came out, certain prescriptions of percentage of marks and all were there, and then qualifications were laid down. So under such circumstances, states had to take permission from the central government for relaxation, because they don't have the necessary qualified teachers and all. So here in this case, central government granted relaxation, but even they went beyond the relaxation and they incorporated things which were not there as per the central government requirement. So in that case, in this case, the division bench essentially held that since the central act prevails over the state legislation which is violative of the central legislation is.
so it's not the case.
But my case is not that. My
It's
case
not-
is
it's
that,
not your case.
yes, it is not my case, but here, my case is that since the rule clearly, since the existing rule allows me to be
What is the existing rule?
eligible, that is the NCD Act, which is the,
Are you not bound by NCT Act?
it is.
Yes, your lordship.
Are you not bound by NCT?
Yeah, we will be bound, your lordship.
Okay.
However, your lordship, as I have stated, the petitioner is saying that, okay, your lordship, we can see your lordship, it has been prescribed the minimum qualification. That we have not, it has not prescribed percentage, your lordship. We are meeting that, your lordship, but it's not a bar, your lordship, for the state government to prescribe percentage. That is my question. And if at all, the petitioner is of the view that, yes, state has been done in violation of, protection has been done in violation. Yes, submission is coming in that line. If the protection is in violation of the state, in the central rule. You could challenge that. No, we cannot challenge now again. We will have to challenge because we have been unsuccessful. We cannot come again and upset all the advertisement, your lordship. Challenge, your lordship. Actually, what is on that he should challenge the advertisement, your lordship, but he has not done that, your lordship. So where does his right flows, Your Lordship?
Okay.
The submission.
Tongpok, anything else?
Your Lordship, that is.
So she has warned you not to dig your.
Yes, I am shaking. I am shaking all over, but what to do?
Okay. Heard Mr. Tongpok Pongan concept of the petition. I attended 33 and 34, huh? Hearing. And also heard MS Libika learned concept of the state response. Hearing concluded. CAB.
Lordship, I may be allowed to submit my rulings on scheme. Yes, Your Lordship. Much obliged.
If you want to also submit something, you submit it. So,
Miss Lordship.
Miss Stokely,
Yes,
are you really serious?
Lordship? Yes.
Huh?
Yes, Your Lordship.
If you are serious, we'll dismiss it. What is there? 164.
Yes.
You are relying on 164.
Yes,
It has been
Lordship.
retracted.
Yes, yes.
Huh?
Yes, Lordship.
Then what is the evidentiary value?
Lordship.
What is the evidentiary value of 164?
Lordship, the evidence.
It is retracted.
Lordship,
That to under 313.
just because they have retracted, that do not invalidate the evidentiary value of the confessional statement under
No, what-
164.
What is, that's what I'm saying. What is the evidentiary value of 164?
The evidentiary value of 164 is that it can accused can be convicted under the, which is corroborated with other evidences that documentary.
It is considered for what?
Lordship.
It is considered for what? 164.
That is a confessional statement before the court, Your Lordship, the judicial magistrate.
Now, once it is retracted,
No, so that's why, Your Lordship, I'm saying that the retraction is only an afterthought.
that's what I'm saying. What
On
is
the
what is the
evidence-
evidentiary value?
The evidentiary value is that it can be, the accused can be convicted. One, I can satisfy this court that whatever the confessional statement they mentioned before, the court corroborates with the documentary evidence. And when this court consider that the confessional statement is voluntary and truthful, Lordship. Yes. Though they had retracted everything, Your Lordship, but retracted that.
That is the other way around.
Yes.
The 164 statement can be considered for corroboration.
Yes.
It is not that 164 has to be corroborated.
So, Your Lordship, everything, all the documents, Your Lordship, even the persons.
You are saying
Yes.
this 164
Mm.
is being corroborated by other evidence.
Mm. The other evidence corroborated to the
164.
yes, to the statement.
The
made
person
under-
is-
Yes, 164, yes. Because the person who made the agreement, Your Lordship,
Yes.
all those things they have made, but there was an agreement exchange for purchase of the question papers. And even the exhibit that has been shown before this court
regarding about the execution of the agreement. So what more than documentary evidence?
So you start.
Lordship. Lordship, I may be allowed to take you through. Your Lordship, this is a stake appealed against the acquittal of the accused by the trial court. Lordship may come to page 214. Yes,
Paper book,
yes, Lordship,
paper book,
yes,
214.
yes. Your Lordship, this is the FIR.
Yes.
Yes, this is an FIR dated 27/5/2005. I may be allowed to read the middle portion. As per media,
How many respondent?
Your Lordship, there are,
All of them have appeared.
yes, Your Lordship. There are 7 respondents, Your Lordship, because respondent number 4 has been deleted because she died. Yes, Lordship. So the 7th respondent.
You have tried to file a substitution petition, making the, yes.
Because there would be a hearing because of statements, Your Lordship. So, Your Lordship, as per the media
The
report.
criminal cases, once the accused dies,
Yes,
gets
Lordship,
abated,
yes.
that's all.
It's an attempted bribery and manipulation of official records. Then Lordship may come to the first para. The Vigilance Commission took up the matter to initiate investigations to motor in the recent reported bribery case in the NPSC, which has caught the attention of all concerned, including media. The commission will investigate into the malpractices, manipulation of ancestry, bribery during examination for selection of candidates for appointment to various grades by the staff of NPSC. Then the following persons were involved in the case. Then, Your Lordship, the next page, that is 251. In view of the allegation above, I hereby sumoto register an FIR in Vigilance and Anti-Corruption or Police Station under Section 34, 108-120B, 511 IPC, read with 13(1)B and D of PC Act 1988. And the rest are the investigating agency, Your Lordship, officers. Then the next page, that is page 216. This is the charge sheet which was submitted on 27/6, Lordship, on 3/8/2005. This is a charge sheet submitted. Then the persons of who stand for trial, Your Lordship, number 1.
FIR is page 24.
Yes, FIR is 27/5/2005. 27/5/2005. And the charge sheet was submitted on 3/8/2005.
On
3/8/2005, the charge sheet was submitted, Your Lordship.
216.
Yes, 216. So, Your Lordship, the accused name are shown here. Sri Inna Onan, he is respondent number 2. Sri Imosanan, respondent number 8. Sri Taponse Santam, respondent number 1. Sri Takashi, constable, respondent number 5. Sri Inkon Longkoma, respondent number 7. Sri Tinuwati, respondent number 6. Then, Your Lordship, the next page.
Who has died?
Your Lordship, next page, the number 8. Number 8. 217, the number 8. Yes. Whereas the rest, they have.
Accused number 7.
Yes, under 8. Yes.
Okay, he died, no?
So, Lordship.
During the pendency of this criminal, the appeal or
prior to the passing of the judgment in the
course of the trial.
Yes.
Okay.
Lordship, may come to page 218, the charge sheet. I may be allowed to read the brief charge sheet. On the basis of the report.
Not be required.
Okay, Lordship, then I may come to the list of the seizure item, Your Lordship. The seizure, the page 238, which was recovered from the accused
number 2, in our own room. Page 238. As your lordship told you,
Just this week.
the scissor list, that is on 6/2005. Lordship,
Two,
from respondent number 2 in our own
no,
room.
two, page
238,
238.
yes.
Scissor list.
Yes, yes. The description of article says,
Yes.
yes. So your lordship, the description of article says that is at point 4, Roman J. Non-judicial paper agreement between Onen Jamir and A. Wati Punjin. Lordship. So this is the scissor. Then the next page, 239. This is also from the room of respondent number 2 in Onen. The description of article says 4A. Non-judicial paper agreement between Marlon Jamir and Onen Jamir. Then lordship come to 4E. 4E, page 239.
This is 239 is.
Yes. Scissor list, your lordship. 4A, that is non-judicial paper between Marlon Jamir and Onen Jamir. Then 4E is agreement between Achila Ponjian and Onen Jamir. Then F is 2 slip containing name and address. Then number G is 1 slip containing name and address. So these are all the documents from the accused number 2. Then lordship again 240, page 240. Another scissor list, your lordship.
Yes.
Description of article 6, that is 4F. NPSC candidate ethnic card bunch. So this lordship, and even 241, that is article point 4C, NPSC application form blank bundle. So all these incriminating documents have been seized from the room of respondent number 2.
This is 4C.
Lordship.
Page 2241.
Yes, 4C, yes, NPSC application form blank oblique bundle. Then, so your lordship, all these documents pointing towards the guilt of the accused have been recovered from the seized from the room of respondent number 2. Then lordship may come to the confessional statement of the accused, page 249. Lordship, I may be allowed to read.
Police custody.
Lordship. Lordship.
Confession is made
before
under the police custody.
No, your lordship, it's not before the police custody. It's
not before, when he was
in judicial custody, lordship. All those things I will show, lordship. This is the confessional statement of respondent number 1, Saponse. Suppose 240. Oh, 247, 247, 247. Lordship 247 page. This is respondent number 1, Saponse Santam. My name is Saponse, age 35. My father's name is such and such. Do you know that I am a magistrate and not a police officer? Yes. Do you see anyone here except me? No. Did anyone tell you to make confession? No. Are you making confession voluntary? Yes. Why do you want to make confession? Statement of Saponse Santam under 164 CRPC. I want to make my position and conscience clear. I did not know anything about Imna Onen earlier. However, I came to know him through Takasashi Homeguard Kohima, who resides in my rented house at Para Medical Colony Kohima. He came and requested persistently to pay ₹7 lakhs to Imna Onen, and he told me that I will be entitled to get EAC after paying the amount. but I refused to do that. But on many occasions, that home guard consistently requested me to deliver the said amount. And so he asked me to see him now on and personally at his NPSC office in the month of December 2004. He took me to NPSC office and asked me to wait at the nearby hotel. I meet him through the home guard at the hotel. He took my telephone number and we parted, and after that he started talking to me through my mobile telephone, asking me when and where I could give the amount. I make an appointment to meet him at his residence. He waited me at Timpati Junction in white color gypsy, and I went in my vehicle number such and such. I accompanied him through the vehicle, and after reaching home, I asked him in detail regarding the process, how I could get ESC just by paying the said amount. He told me that even last year, ESC topper 1 and 2, that is husband and wife, could get after paying 7 lakhs, and even year before last, only ESC, DSP who could give that much amount were appointed. This conversation was in December 2004. With that word, I was persuaded and coerced to pay him ₹7 lakh. After that, I went to my village and make arrangement to pay him. He further said that he was such an agent from the controller, and he told me that they used to share the amount from the amount. His share will be only ₹2 lakh and ₹5 lakh for controller. I have arranged ₹7 lakh and came to Kohima. After reaching Kohima, I asked Imna Onan where to give him the amount. He told me not to come to his residence and to arrange one hotel room for the transaction. So I arranged one hotel room at Capital Hotel number 309 around 6:30 p.m. on 19 or 20 December 2004. We made the transaction in that hotel, and he has shown me at his mobile capital letter B, which means boss, that is controller, and he told he would go to controller residence with the cash straight away. That was how we made the transaction. So this was made with an agreement to give me question papers days earlier or before prelim exam, also for main exam and for viva voce. If I could secure very high rank or merit in written exam, then in the interview, there is no chance to delete my name. He also told me that in the previous year also, it was done in this way. So I have received back ₹5 lakh from Imna Onan. I'm still going to receive the remaining 2 lakhs. Imna Onan told me that question paper were with Chada, board chairman, so he could not give me the question papers at that very point of time and asked me to take back the cash. So
who is this?
This is respondent number 1.
Who is he?
Sapon Se.
Is he aspirant?
Lordship. Yes, he is an aspiring candidate, Lordship. So in order to get the question papers, 2 days before the prelim exam, he paid ₹7 lakh to Imna Onan, respondent number 2. In the
Respondent number 2 is
Imna Onan.
who is
He is the
official of the
he is the staff of the NPSC, Lordship, yes.
Okay.
Respondent number 2. So the transaction was made between at Capital Hotel room number, and even the timing, everything has been mentioned. But Lordship, respondent number 1, he retracted his confession statement at page 319. His confession statement under 318, Lordship, under 313. 319. So, Your Lordship, here he retracted his confession. Page 319, the examination upon says until question. The evidence is shown that you have contacted Imna Onan through Takasashi for securing MPSC question papers in advance for 2000 exam. What have you to say on the chart? Takasashi has no role in the transaction of money in the instant case. It is only learned that Takasashi is from the same village of accused Imna Onan. We have not discussed anything about the question paper. Question. Evidence is on record that you have paid ₹7 lakh to accused Imna Onan at Capital Hotel Room 309 in the month of December 2004 for securing the question papers in advance. What do you say? Answer. There was no transaction at all. Then question. You have anything to say generally on the case? Answer. On the issue of confessional statement, I am to say that I was threatened by the investigation and compelled to make statements which are not true. Certified that the above statements are correct and true as recorded by the accused on 2417. But your lordship may come to page 280, how the confessional statement, it was done before the judicial, when they were in judicial custody.
Page
280 and 287, your lordship.
reflection was given,
Lordship,
20 minutes, 30 minutes.
lordship. The respondent number 1, he says that he was compelled to make the, threatened by the police, the IO investigating agency, to make such statement before the magistrate. Yes, and more or less he's saying that his statement were taken at the time when he was in the police custody. But your lordship, if we read this, it reveals everything. That is at page 280. This is the statement of the assistant IO. Page 280, your lordship, the last, just above the cross, the last
Is the evidence of position of
Mionand, assistant IO, lordship,
assistant IO.
page 280.
Start from page
280. It starts from page,
276.
yes, lordship. So 280. So your lordship, just above the cross, the last sentence, just above, just above the cross. I remember taking the accused Imna Onan to record his statement on 28/6/05. Lordship, this one is with regard to, this is Imna Onan, lordship, 287. Lordship, it will be 287, because this is with regard to respondent number 2. 287.
287.
Yes. Just above the cross by KL John for Taponse. Yes. The last cross, your lordship.
This is not, you are not relying 280.
Lordship, I will be, but different accused has different. Yes. So here it says, in the present case, the confessional statement were recorded in respect of all accused persons while they were in judicial custody. Yes. Then your lordship,
all of them have confessed.
Yes. Well, they were,
A confessional statement.
yes, while they were in
All
judicial,
of them.
yes. They were in judicial custody, but at the time of examination under 313, they had retracted their statement, saying that they were forced by the investigating agency to take the statement incriminating against them, lordship. Yes. Your lordship may come to the confessional statement at 253 of respondent number 8.
253.
Yes.
Why not go by serial? Serially?
Yes, just to make a comparison, your lordship, how they have retracted their confessional statement. 253, this is respondent number 8.
No, what else? 253.
Lordship, sorry, my apology.
What I
lordship.
am saying is, why don't
Yes,
you serial?
249, yes, lordship, 249.
Respond number 1.
Respondent number 1, 247,
5, 7.
yes.
Like that.
Respondent number, according to the respondent, lordship, okay, lordship. Okay. Then respondent number 2 is at page 251.
You are representing all of them.
I'm representing 2 and 3.
2 and 3.
Yes. And
What
the
are
others
we-
also represented.
Oh, they are there.
I'm representing 1.
Okay. All of them are there.
Yes, no.
Lordship, respondent number 2 is.
How long will it take?
Lordship, I'll just give,
7 days.
no, lordship, I'll be very brief.
I'm here for 10 days. Next 10 days I'll be here. 13 days, 10 days.
I'll be brief, your lordship, just to show the comparison between the
Yes.
confessional as well as
Okay.
that one, and I'll rely on some judgment. Yes. So lordship, page 251, this is the confessional statement 1 of Art 2.
$164 statement.
Yes. This is Imna Onan, your lordship, respondent number 2. He stated that I took money from 3 persons, telling them I could help them in NPSC exam. Do you know that I am a magistrate? Yes. Are you aware that your confessional statement has to be voluntary? Yes. That whatever you confess will be used as evidence against you during the trial of the case? Yes. Confessional statement of Imna Onan on 29/6/2005 at 12:35 p.m. I am to make further clarification that Mr. Im Kong, from whom my father arranged the money, as long got lost. But when for return of the money, I volunteered to help his daughter. He agreed. But I could not help his daughter because I was terminated and not working in the office anymore. The transaction took place on 2nd December 2004. During the transaction, he was also present, and it was in his house, and his wife handed over the money to me. This additional statement was recorded on 29/6/2005 by me for accused Imna Onan, who voluntarily came to give his statement. Then another confessional statement, for which I was caught by the vigilance, so I am here. The 3 persons are Imosanen, Sipose, Imkon. From Imkon, my father arranged the money, for which I went to receive the money, which was meant for me and not for NPSC exam. But unfortunately, the money got lost. I told Mr. Imkon that in return for the money, I'll help his daughter, for which he did not agree. Neither I could help his daughter. The amount is rupees 5 lakhs. From Imosanen, I took rupees 6 lakhs and rupees 7 lakhs from Tiponse, telling them that I could help them in exam, which I could not do so. So I have returned all their money to them. In order to win their confidence, I have told them that I have done this, for which is a lie. The commission also terminated me from office, and I was not allowed to appear in PSC exam. None of them qualified in MPSC. There is one more guy with whom I have told him about this thing, but the amount was too much for him. So I asked him to let, but he could not pay. So there was no deal at all. His name is Tinuwati. I did all these things because of controller, and me had a talk about doing this. But when I went to his place, he did not agree with me. That is why commission first caught me, because he reported to the commission that I tried to bribe him. So your lordship, all along in his confessional statement, he says that he took rupees 6 lakh, 7 lakh, and 5 lakh from different accused persons, lordship, in order to give question papers to them. Then how he retracted his statement, that is at page 321, your lordship.
But then you, from 164, you saw that sufficient time was granted for reflection.
Lordship, so that is the only thing, your lordship. Otherwise, I can read the lordship of the IO, who lordship may come to page 273. The magistrate who took the confessional statement, everything is very clear that sufficient cool reflection has been given to them. So your lordship say, when there is documentary evidence, your lordship, when the person who executed the agreement,
is it allowed that you cannot make you cannot retract it?
They always retract, that is the right which they have, but that retraction is an afterthought only, on the advice of their counsel, your lordship. Yes.
How do you say?
Because the Supreme Court says so, your lordship. Supreme Court has clearly says so, because on the advice of the counsel, many of the accused, they retracted the confessional statements.
So in this case, do you have anything to show that on the advice of the counsel they have retracted?
Obviously, your lordship, otherwise in the confessional statement, they have made it very clear that they did mistake. They make try to purchase question papers.
That is the reason. Reflection is very, very important.
Yes, but just because they retracted doesn't mean that
when you are in the, you could understand when you are not arrested, when you are not in the jail. That is the reason reflection is important.
Lordship, but just because they are retracted doesn't mean that the evidentiary value that the confession statement before the judicial magistrate has to be done away with, has to be brushed aside. No.
Brushed aside, that has been considered, and that is.
Yes, I'm going to show you the documents which support your lordship, those everything.
Proceed.
Lordship, then
page 51.
Page 351, as to how respondent number 2, he has contracted his confessional
Three
statement.
51.
Yes, Lordship. 321, Lordship. Your Lordship, this is Imna Onen. He is respondent number 2. It has a question. It has been charged that you have contacted candidates for the 2005 NPSC exam and collected money for providing NPSC question paper in advance. It is alleged that you have collected a sum of 6 lakhs from a particular candidate, Imo Sanen. What have you got to say about this?
This is
incident?
313 statement.
Yes,
yeah?
313, Lordship.
Yes.
I have not collected the money, nor have I passed question papers in advance. Then the next question, is it true that you have collected a sum of rupees 7 lakhs from a prospective candidate, Mr. Taponse, for providing question paper in advance? Answer, I have not collected any money from Taponse, the candidate. There was no transaction. Question, it is also alleged that you have collected a sum of rupees 5 lakhs from engineer Incon to facilitate his daughter in Likokla to get through the NPSC exam. The transaction was shown as a loan. What do you say about that? Answer, it was a loan secured by my father from a friend, engineer Incon, and I was endorsed to collect the same. Question, it was also alleged that you have collected a prospective candidate, Tiniwati, to pay rupees 2 lakhs for passing question papers. This was, however, not paid, and the investigation was started before the agreement could be executed. What do you say? There was no agreement, there was no contact, it is just a friend. What do you want to say on the case generally? Answer, this is only manipulated and I was forced by the vigilance to admit. Certified that the above are correct and the statement recorded by the accused Imna Onen. So, Your Lordship, the only way he retracted his confessional statement is that he was manipulated and forced by the vigilance to admit it. But if we see the examination of the IO, Your Lordship, this says that the confessional statements were taken on several occasions where they were in a judicial custody, Your Lordship, not in the police custody.
Where it is?
Lordship, that is at page 280. The IO of the case. 280. That is 280, the last paragraph just above the cross. I remember taking the accused Imna Onen.
Ayo.
Yes. I remember taking the accused Imna Onen to record his statement on 28/6/2005. I personally, along with other personnel, took him before the court of GMFC Kohima to record his confessional statement. He was produced before the GMFC on 2 occasions by me. He was lodged as SP Kohima at the time. His confidential statement were recorded on 28 and 29. The witness corrected himself that the accused was in judicial custody at that time.
Yes.
Yes. Yes, he corrected himself by saying that
SPS is South PS Kohima.
yes, South PS recorded the witness correct himself that the accused was in judicial custody at that time. Then, Your Lordship, respondent number 6.
So you are not,
Confessional statement, Your Lordship.
you are not against respondent number 3.
The other, Lordship, that is not annexed here, Your Lordship. But these persons are the main where we can gather all the evidence, Your Lordship.
Who is the controller?
Your Lordship,
Controller is not an accused.
no, because during the investigation, Your Lordship, there was no material.
Only this official.
Yes. So he was,
Officer is this the respondent 2 only.
yes, respondent number 2 and respondent.
Your Lordship, 4 was the principal accused.
Okay.
She was an assistant director in the NPSC at that time. 2 is her son, 3 is her husband, 2, 3, and 4.
Which
But as Your Lordship already pointed out, the controller of examination was never an accused in this case.
2 is his son.
2 is his son who was
His son.
LDA appointed on temporary basis at that point of time.
LDA. And 3 is
Husband.
Three is the husband,
And
and
four
four
is
is
the
the,
lady who expired during the
Because-
trial.
she is the secretary.
Okay.
Deputy, yes.
Deputy secretary.
Deputy secretary, yes.
So, Lordship,
Then three is not the husband.
Mm.
He was not connected with the LPSC.
No, he was not correct.
but regarding with the other allegation, Your Lordship, regarding with the manipulation, not with this one, but another case, tabulation of marks.
We are not concerned about the other case. We'll have to go by the merits of this case.
So Lordship, again come to page 248 of the paper book, the
248.
yes, the confessional statement of respondent number 6, Tiniwati.
Just wait.
Mm.
Assistant Secretary, sorry, Assistant Deputy Secretary.
Mm.
Deputy Secretary or Assistant Deputy?
Deputy secretary. She was deputy secretary at that point of time.
R2 is, he's
A2 is R2 is the son,
LDA.
LDA.
Yes.
Hmm.
And R3 is the husband.
Yes.
Mm. So Lordship, page 249, this is respondent number 6.
No, that's what I'm saying. What about R3?
Lordship,
Let us go serially for the convenience.
in the confessional statement, Your Lordship, R3 has.
There is
not
no
been-
confidence
No,
statement.
he has not been given here, Lordship.
It has not been given or he has not been, he has not made any statement under 164.
For that matter, Your Lordship, but he was, I don't know, Your Lordship, but in my paper book, I have not, whatever the confessional statement I have annexed in my paper book, yes, Lordship.
So when you are basically on
But
160, why R3 should be there?
Why R2 came into picture is that the R2, his son, says that his father had asked for a loan from R.
Very confusing.
Yes. From R7, Your Lordship. So that is how R3 came into the picture.
Why R7 is there? The
R7 is there.
person who gave
Why
the loan should be accused.
Yes, R7 is an accused here because R2, he lost the money which R7 gave it to his father. So in order to repay the money in the form of
Suppose I take a loan from you.
yes,
Should you ask me what more and what not? If you can give me, it's up to me. Where I spend and where I'm not. Is that it?
Lordship.
Suppose I take a loan from you,
Mm.
I spend it whatever I will feel like.
Mm.
Only that I should not be default in payment.
Yes, Lordship.
Then where I spend, how I spend, what does?
No, when R7 came into picture is that R2 and R7, they came into an agreement again after the loss of the money that R2 will supply the question paper to his daughter.
Okay.
Yes.
Because
Because
is a statement of agreement of R7 and R2.
yes, Lordship. But because from the confessional statement also, it's very clear that R2, he has stated that Lordship, if you read at page 252, 252. Unfortunately, the money got lost. I told this is R7, that in return for the money, I will help his daughter, for which he didn't agree. Neither I could help his daughter, the amount is rupees 5 lakhs. So, Your Lordship, there was a communication between R6 and R7.
From whom he has taken,
Yes,
then he has asked a loan from him. So that he'll supply this.
Yes.
to his that.
So that's how our servant came into picture. So Lordship, page 249, this is R6.
Hmm. Yes.
My name is Tinuwati, R6. Do you know that I'm a magistrate? Yes. What you confess will be used as evidence against you during the trial of the case. Are you aware? Yes. Are you giving a voluntary statement? Yes. Confessional statement of Tinuwati under 164 recorded at 2:20 p.m. Imna Onen, this is R2. Imna Onen is R2. Imna Onen and me are friends for about 1 or 2 years back. When we meet, we casually talk hi, bye friends. One day we met in town and he told me about his divorce and also asked me to find a suitable girl for him. Jokingly, I replied that I am also in the same position as he. During November to December 2004, he called me up at home through telephone and asked me if I am appearing in forthcoming NPSC exam. I replied in affirmative. He said that he is selling question papers for NPSC for ₹5 lakh. So he asked me if I am interested, to which I replied that I don't have that much money, nor am I interested as such. Before I went for Xmas holiday, he again called me through telephone and said that I should at least pay ₹2.5 lakhs. So I replied the same as before. During that time only, he said that since now I am aware of his involvement of selling the question papers, I should at least arrange for 1.5 lakhs. So again, I replied that I'm not interested. During February, March 2005, again, he was still inquiring and asked for the same amount of ₹1.5 lakh. So again, I replied, I'm not interested. That is all. Our last conversation was during May 2005, right after the publication of NPSC scam. Out of curiosity, I asked Imna Onen as to who were the person that were called. He replied to go through the newspaper and I'll know if it from there. Then on 15/6/05, that all the statement I make on 13/6/2005 are true and correct. That Imna Onen first asked for ₹5 lakh. Secondly, he came down to 2.5 lakhs and finally to 1.5 lakhs, to which I declined to pay for NPSC prelim question papers. I had no money, nor do I was interested. As it was too tempting, I discussed the matter with my mother, but she was totally against it. Further, she told me that we have no resources. I never bargained, nor did I have any deal with Imna Onen regarding NPSC preliminary question papers. So, Your Lordship, if in his statement before the court will reveal many things, Your Lordship, 318, page 318, Your Lordship, of R6. This is Tinuwati. Yes. It is on evidence that you had contacted accused Imna Onen for securing question papers in advance for the NPSC 2005. It is also reported that an agreement was reached upon between the two of you that a sum of ₹2 lakh would be paid for the same. The transaction was, however, not executed. What have you to say on this evidence brought against you? Answer. I have not contacted accused Imna Onen, nor have we made any agreement for payment of ₹2 lakh. You have to say anything on this case generally. It has been 8 years now, and I want to get over it. Certified that the above statement are the true statement recorded by the accused Tinuwati. So, Your Lordship said, though he has not retracted anything, rather he is admitting, Your Lordship, that it has been 8 years now and he wants to get over it. Then, Lordship, again come to page 253 of respondent number 8, confessional statement.
Page
253. This is the confessional statement of respondent number 8.
Yes.
Lordship, my name is Imo Sanen such and such. Do you know that I'm a magistrate and not a police officer? Yes. Do you see anyone here except me? Yes. Did anyone tell you to make confession? No. Are making Are you making confession voluntarily? Yes. What do you want to make confession? Inna Onand, this is R2. Inna Onand, who works at NPSC, approached me. He told me that he is the agent of controller. Since he worked there, also his mother, I thought he was a real agent. Since everywhere talks about the corruption of NPSC or any other department, I thought without money to get the job is difficult. That is on 8/6/2004. Again, on the next date, since Imna Onan R2 is asking money for appointment for NCS Allied Services, saying that he is an agent of controller, so I thought that it was true, and I was too confident and gave him ₹6 lakh through my sister Achila Ponjan. After that, some days, Imna Onan came and returned the money, saying that this time it is difficult. So I asked him why. He said that the appointment cannot be made. Then after some days, MPSC office called for me. Only on that day, I came to know that I have to be debarred from appearing the exam. So I requested them to appear for the exam since I was not guilty, but saying that it is MPSC rule. They asked me not to appear in exam, and they asked me to sign on a statement given by Imna Onan, saying that nothing will happen and it is confidential. Chairman, secretary, and controller told me that they just wanted to know whether Imna Onan has returned all the money or not. So I replied that it has been returned to me. Repeatedly, I requested them and PSC to allow me to sit for exam, but they refused. Also saying that I am young and energetic and not to feel bad, but to try again next year. Imna Onan, I know him for only 2 to 3 years. On the night we were arrested, he was carrying tablets. I never knew he was such a man. I trusted him because he said he works in confidential branch. And since his mother is also an officer there, and he also said that he is the agent of the controller. He rang me up at Mokochun, asking me to come along with money soon or else there are other candidates. That time my mother was sick and she expired on 10/1/2005. So my sister came with money only after that. So Your Lordship, the retraction of the statement of R8, that is at page 324.
324.
Yes, he retracted his statement in 324. Page 324, emotion, and this is respondent number 8, Lordship.
Emotion.
Yes, respondent number 8. Question. During 2005 NPSC exam, it has been alleged that you had approached accused Imna Onan for providing question papers in advance. Allegation is made that Imna Onan had demanded ₹10 lakh from you. What have you to say against this evidence? It is not true that the accused Imna Onan demanded money from me. The vigilance had kept me under arrest for 15 days. I have not approached him for the question papers, nor have he discussed about the money. Second question, regarding the allegation of transaction out of the 10 lakh demanded from you, you have settled the amount for ₹6 lakh, which was paid to accused Imna Onan. What have you to say on this evidence? Answer, I have no idea about the money as there was no discussion. Next question, due to the revelation of the transaction for advanced question papers between you and accused Imna Onan, the NPSC has debarred you and accused Imna Onan from appearing the NPSC exam. What have you to say on this issue? During the investigation, I was forced to make confessional statements while in vigilance custody, and I was tutored by Imna Onan to state that I had paid money. See, Your Lordship, he is again pointing towards his co-accused, Your Lordship, that he was tutored by Imna Onan to state that I had paid money. Accordingly, I gave the statement to the vigilance. This might have been used against me to debar me from giving the exam. Is there anything you want to say generally on the evidence that has been presented to you, considering that your lawyer has already presented to you the charges and evidence brought against you? I do not think I have committed any mistake in this case. So Your Lordship, here all the accusers, they have retracted their confessional statement. Now come to the person who had paid the money to respondent number 2. And executed the agreement, the confession, the statement, Your Lordship. This is the cross, the examination of the position of witness number 6. This is Temsu Chila, the sister of respondent number 8, who paid money to respondent number 2. Page 264, Your Lordship.
264.
Yes, Lordship.
This is accused number?
She is the prosecution witness, Your Lordship.
Huh?
Prosecution witness.
Okay.
Yes. She is the one who paid the money to respondent.
6.
Yes. Respondent number 2. Accused number 2. She is the sister of respondent number 8.
Okay.
Yes, and she is the one who paid the money to respondent number
number
2 by executing an agreement. Lordship, I may be allowed to read on oath.
Yes.
I am doing my business in connection with traveling agencies in the Department of Transport and Communication. Since 2004, I have been including in this business. I know the facts of this case, which is related to NPSC scheme. I know accused Imo Sanen, who is my younger brother. My brother accused Imo Sanen, who is my younger brother. My brother accused Imo Sanen had applied NPSC examination form for the post of EAC, DSP, and other allied services. In the last part of 2004 till 2005, first part accused Imna Onen. This is Imna Onen is respondent number 2. Approach accused Imna Onen, who is working in the office of NPSC as LDA, approached me to arrange rupees 10 lakhs for my brother. Accused Imo Sanen to get passed in NPSC exam and to get appointment in the post of EAC or DSP or other allied services. And in due course, I had negotiated with accused Imna Onen and settled to rupees 6 lakh only. And over the said amount in cash, along with my elder brother to Imna Onen, the defense counsel objected for examination of this witness. Thereafter, we returned back home. And after a few days, my brother's Imo Sanen was arrested by Vigilance Commission. After this, my brother accused Imo Sanen could not appear in NPSC exam because he had been debarred of NPSC. Her pros. I reiterate the statement. I had paid rupees 6 lakhs to accuse Imna Onen, this is R2, for securing a job for my brother through NPSC. I say that the demand for rupees 6 lakh made by Imna Onen initiated from him, as he used to telephonically inform me to arrange the money and pay. The demand for rupees 6 lakh was made to me by Imna Onen, as I believe that being the elder sister of Imo Sanen, Imna Onen thought it proper to demand the money from me. In my opinion, accused Imna Onen did not demand the money from accused Imo Sanen. I say that while I paid the amount of rupees 6 lakh to Imna Onen, accused Imo Sanen was not aware that I had paid 6 lakhs to secure a job for him. I see that accused Imna Onen only subsequently came to know that I had paid rupees 6 lakh to Imna Onen to secure a job for him. This knowledge was through my information. Again, another clause by defense counsel for R2. I paid the amount of rupees 6 lakhs by borrowing half the amount from others and half from my business resources. I borrowed rupees 50,000 from my friend Asantla. I also borrowed from my brother Wati Ponjin. Wati Ponjin is my brother and met my friend. However, I don't remember how much I borrowed. I don't remember from which other person I borrowed. The balance of the amount I do not remember exactly of which date I paid rupees 6 lakhs to Imna Onen, probably in the month of January, February 2005. My brother Wati Ponjin and myself paid the money to Imna Onen at his residence. When I paid the amount of rupees 6 lakh to Imna Onen, an agreement was drawn up as a loan. This agreement was submitted to the Vigilance Office by me. I'm not aware that if my statement against Imna Onen are correct, as the person paid the money, I am also criminally liable. The officer of the Vigilance Commission News informed me that my admission to them of paying the money to Imna Onen also attached criminal consequences and that I am also liable to be charged under. I have never been arrested in connection with this case. It is correct to say that whatever I have stated that I did was for the interest of my brother Imo Sanen. I agree that it is strange and that in law, the person making the payment is equally criminally liable as the person receiving the money. Only Onen has been arrested and I have never been arrested or made an accused in this case. It is correct that the entire amount of rupees 6 lakhs was returned to me by Imna Onan. It is correct that when the statement was recorded by IO on 8605, I told him that out of the total amount of 6 lakhs, only an amount of 4 lakhs had been returned to me. As on that day, I do not remember what exactly the amount of 4 lakhs was returned to me. The said amount was paid to me after Imna Onan was released on bail, but I do not remember the exact date. I am not aware as to whether all arrests of Imna Onan and his family, including bank account, etc., was seized by officer after Imna Onan was arrested. I do not remember when the balance of 2 lakhs was paid to me by Imna Onan. It is correct to say that in terms of loan agreement, which I myself submitted to the Vigilance Commission, Imna Onan has repaid to me the principal amount of 6 lakhs. However, to semi interest at the rate of ₹5 per month. However, we have mutually decided I will not demand any interest and they also do not pay any interest. I do not agree to the suggestion that my statement against Imna Onan are because I agree with him for repaying my money at a related stage, and also that since my brother is an accused in this case, I am trying to portray him. I do not agree to the suggestion that the case against Imna Onan and others is a cook-up case and that I have been made a party to the same in Vigilance Commission. In her re-examination, Lordship, my brother accused Imna Onan and accused Imosanen and accused Imna Onan. They know each other. My brother accused Imosanen to go to Kohima and meet accused Imna Onan. Seeing a close friend, my brother accused Imosanen was in the knowledge that he will be getting ESC or any other allied post through NPSC. The event purpose of loan agreement in this is to secure the post of ESC or any allied post through NPSC. In her recross, I say that the relation of my brother Imosanen with accused Imna Onan does not give any prospect to accused Imosanen to secure a job in the NPSC. So, Your Lordship, in all her cross-examination, the person who executed the agreement, Your Lordship, says that the agreement is meant for purchase of question papers for her brother, Your Lordship. In all the, then, Your Lordship, this statement of the witness corroborated with the statement of respondent number 2. I'll show you the corroboration. That is at page 256. Lordship, this is the 256. This is Wati Ponjin. Wati Ponjin is the brother of defense with prosecution witness number 6.
Very difficult, not legible.
Page 256, Your Lordship. This person, A. Wati Ponjin, Your Lordship. Page 256.
Yes.
This page 256, A. Wati Ponjin, Your Lordship. A. Wati Ponjin is the brother of defense witness, prosecution witness number 6. And he and her sister, in order to get a job for the brother respondent in, they approached respondent number 2 by paying ₹6 lakh by making an agreement so as to secure the question paper, Your Lordship. So this is the confessional statement before the W.A. Wati Ponjin before the court, Your Lordship. I may be allowed to read. 256. My name is A. Wati Ponjin, aged about 32. My father name such and such. Whether it is rumor or true, we hear people talk about appointment after payment of money. So when Imna Onan, respondent number 2, phoned us through his mobile number such as such at Mokochun to such and such, asking us to bring money immediately for NPSC allied service, and that work will be done as he is controller's agent. He asked for ₹10 lakh, so I bargained for ₹5 lakh, but he consented to ₹6 lakh, and we gave him 6 lakhs, out of which he has already returned 4 lakhs only after the prelim exam, and he is yet to return 2 lakhs. Then another confessional statement is, In fact, we believe in Onan, as he said, he is controller agent also. His mother is a high officer in NPSC and he worked as LDA in the department. I have explained to him the formality under section 164 CRPC, the statement read by him and admitted correct. So, Your Lordship, even the brother also in his confessional statement that he paid rupees 6 lakhs to respondent number 2.
We'll continue tomorrow.
Lordship, tomorrow I have a difficulty. We may continue on Monday, then, Lordship.
Monday. In any case, you will not be able to complete. Mr. MS B. Sokri, Leonard PP. Press. Appellant, Mr. B. Jimobi, Leonard. You are for respondent number 1.
Number 1.
Pongan for respondent number 1. A. Jimobi for respondent number 2, 3. 2 and 3. You are for 2 and 3. Who is for what? You are for?
6.
6. Respondent number, oh, sorry. On MSB Sokri Learned Public Prosecutor for appellant. Then T. Pongenor for respondent number 1, A. Jimobi for respondent number 2 and 3. And Poseco 44, respondent 6. Who is for 5? No one is for 5. 5 and 7. 5, 7, 8. None appears for respondent number 5, 7, and 8. Kindly inform Learned Counsel appearing in this matter. Inform that we'll continue on normally. Hearing remains inconclusive. Listing matter. Hearing to continue on Monday is 18/9/2020. List on Monday. 18/9.
Case may be marked as part heard, so that there's no confusion.
We'll see. We'll see. She made me sleepy.
This is actually a very sleepy case, man.
We'll continue on Monday. First half will start. Okay. Yes. 36. Is partner or what? Not partner.
Tuesday, next week. Lordship, let this matter come on next week, Lordship, Tuesday.
Where is Mr. Leonard Edison AG?
Lordship, I'm appearing on his behalf, Lordship.
Is supposed to, did you obtain anything?
Lordship.
ROP and all those. Huh? We'll fix it in Tuesday, but you can we go through this order 22/8/23?
I'll inform you.
And then not inform you, go through this just now.
Lordship.
According to take, and also you also.
Lordship, we are yet to receive instruction
Huh?
regarding, we are yet to receive instruction regarding the last order.
Next week we'll see. Tuesday.
Item 37 and 39, there are a similar matter, Lordship. If this can be taken after 2 weeks, Lordship.
No, not 2 weeks, next week.
Lordship.
Next week.
In that case, on Thursday, Lordship,
30,
37 and 39, Lordship.
37 and 39. Next week.
Much of it.
Please, Lord. Should let it come up next week, Lord.
Next week, huh? You just record the name of the council and on the prayer of council for the parties list is matter next week for the hearing.
Next week.
42?
What if this matter can be passed over for today, Lordship?
What 50?
50, Lordship.
What is this?
Lordship, I'm seeking for a regularization, Lordship.
Tomorrow?
Tomorrow, Lordship.
Huh?
Yes, Lordship.
Or next week?
The convenient of this honorable court, Lordship.
And next week?
On Monday, then, my lord,
You are
Monday.
for
19, I'm for the state.
State, Lord.
urgency is there.
No, my lord, from 21 to 28, I'll be out of station.
Huh?
So 21 to 28, I'll be out of station. So before 21,
This is a matter of 2021. Then after 2 weeks,
19.
after 2 weeks. Lordship, urgency is there. Is there any urgency?
Lordship, only for regularization, Lordship. I'm in service, Lordship.
So after 2 weeks, it's in 2021 matter.
How much is Lordship?
55?
Your lordship. Your lordship, kindly listen matter on Monday.
55.
Yes, your lordship.
What is the urgency? 22 matter. Monday is not possible. You have seen that one pardon matter.
Just your lordship.
After 2 weeks. Or after a week.
After a week, your lordship,
After a week. Yeah, for petitioner.
for the petitioner.
So and so, and consider the petitioner. Only prayer of so and so, and consider the petitioner. List this matter. After a week.
Bless your lordship. Please, your lordship. Your lordship, can you fix this matter on Monday?
Monday it's not possible. It's 2020 matter, 23 matter.
After
After 3 weeks.
for
Huh?
version of the FIR,
That's
and the
it.
FIR has been withdrawn, your lordship.
Withdrawn.
Yes, your lordship.
So in that case, after 4 weeks. All right.
No, your lordship,
On Tuesday, Lord.
Huh?
then can you fix it on Tuesday?
Why, what is the urgency?
Our Lordship, since the NSF, they are withdrawing the instant FIR. So Lordship, we want the speedy disposal, Lordship, of this matter.
Why? FIR can be withdrawn.
Lordship.
Can it be withdrawn?
Lordship,
Can it be withdrawn? Any case diary? Do you have the case diary?
no, Lordship.
It's of 2023, where this has been listed for hearing.
Lordship, in that way, the matter, let it come on Thursday, Lordship.
What is the issue? What is the offense?
The offense is under section 457, 427, and 120B. And 134 IPC.
Page 9.
Page 9.
Lordship. And the type of is page 10.
No. No.
The additional affidavit.
Ah,
Additional affidavit filed by the,
not in the main petition.
not in the main petition.
Why?
Your lordship, when this criminal leave petition was filed, we were unable to obtain a copy of the FIR. And considering the urgency involved in this case, we have approached this honorable court without the FIR.
Page 9,
Yes,
that copy is.
Page 10. Type copies of page 10. Additional affidavit filed by the petitioner.
Has been demolished this name. It has not been demolished. It has been demolished.
yes, your lordship.
So why FIR has been withdrawn?
Lordship, since there has been a compromise between the two parties, lordship.
So it is permissible. Is it permissible under the law?
For withdrawal, they have also intimated to the CJ Kohima lordship, which is a page 12. Page 12 and the type copies of page 13.
So we'll take up tomorrow then. Tomorrow.
Lordship, tomorrow I have some pre-engagement, lordship. So if this matter can come up on Monday, lordship.
Monday.
Lordship.
On the prayer of Mr. B.G. Mobi, Learned Council, Learned PP, list this matter on 18/8/9/2022. MS so Learned Council for the petition present. Why urgency is there? Once you have withdrawn the FIR.
Since the FIR has been withdrawn, your lordship.
So why urgency is there? What is the urgency?
The parties want to close the cases.
Okay, there is the urgency.
I remember 58.
Okay.
No, please, your lordship. If this can be listed next week.
Next week,
On Thursday, Thursday,
Thursday,
next week, Thursday.
on the prayer of the Learned Council for the heart so and so. We mentioned on the prayer of the Learned Council for the party, list this matter on Thursday is 21.
21. 21. God bless you.
Blessed.
Yeah.